You know what? It's okay.
No, I have like a really long reason.
Time session.
Thank you, and please be seated. And good morning, everyone. My name is Curry Mingledorf. I'm assigned to preside over this morning's proceedings. We're here for a limited purpose this morning. I do want to note for everyone's benefit that there is, as everyone certainly is aware, considerable interest in what has occurred in our community in the last several days. For that reason, the court has seen fit under Rule 22 of the Uniform Superior Court rules to allow media outlets to record some of these proceedings. However, under those rules, the court has set in place certain limitations, and I just want everyone to know that the media has been informed of that, and I'm confident that they will comply with that. But otherwise, there is to be no filming or recording by any members of the public or any other individual other than those authorized specifically by the court in its signed ruling. Are we ready, counsel, to begin and bring the defendant in?
State's ready, Your Honor.
All right.
Defense is ready.
All right. All right, good morning, sir. Are you Mr. Colt Gray?
Yes, sir.
My name is Curry Mingledorf. I'm assigned to preside over this morning's proceedings. Mr. Gray, I do need to inquire as to whether you're able to read and write the English language.
Yes, sir.
All right. I also want to inform you, I want to ask you, do you understand that you have the right to be represented by an attorney in these proceedings?
Yes, sir.
And you are, in fact, represented today, is that correct?
Yes, sir.
And Mr. Zane Harmon, you're here on behalf of this defendant, is that right?
Yes, Your Honor.
All right, and you understand that you have the right to be continuously represented throughout this proceeding, and if you cannot afford to hire counsel, then this court is obligated under the Constitution to provide counsel for you without cost to you. All right, I am going to inform you of a few other matters, and I'm not going to ask you anything, just inform you. So one is, I want to make sure that you are aware that you have the right to remain silent. You don't have to say anything at all. And it's important to understand that because anything you might say could be used against you at further proceedings associated with your case. I want to inform you of the charges that you currently face. In essence, you are charged with 4 counts of felony murder, as outlined in the state warrants that have been issued against you. I want to make you aware that the maximum penalty for felony murder, so for each count, the maximum penalty is that you could be punishable by death, by imprisonment for life, without parole, or by imprisonment for life, with the possibility of parole. If you have any questions about these charges, then I would urge you to discuss those with your attorney. I would invite you, Mr. Harmon, to inform the court as to whether there's a request for bond at this time.
At this time, Your Honor, there is not a request for bond. We will file the appropriate motions if that becomes necessary.
All right. An indictment by the grand jury for most felony offenses or accusations well, you have the right to receive an indictment for these offenses. And I assume Mr. Brad Smith is here on behalf of the DA's office, or he is our district attorney, and he's accompanied by Ms. Patricia Brooks, who is his chief assistant. A preliminary hearing, you'll have the right also to a preliminary hearing, unless you make a bond, which of course at this point there's no bond being requested, or unless you waive such a hearing. You have the right to a speedy and public trial by a judge or a jury. You have the right to confront and cross-examine all witnesses. You have the right to call witnesses on your own behalf and testify in your own defense if you so choose. As you sit here in this courtroom today, under the law, you are presumed innocent. Your refusal to testify at any point in any proceeding will not be used against you in determining whether you are guilty or not guilty. Counsel, let me just inquire as to whether there are any other items that the court should address before we conclude this preliminary hearing.
No, Your Honor.
No, Your Honor.
Well, I do have one piece of information to convey to the court. There was a development yesterday afternoon that makes it necessary for our office to have alternate counsel appointed, and arrangements have already been made in that regard. I've already explained that to Mr. Gray, and alternate counsel will be appointed by the end of the day today.
All right, thank you very much, Ms. Donna C. Graves. All right, then with that, this hearing is concluded, and you may escort this defendant out. All right, with that, I understand that we have another first appearance hearing, and I think that we're going to have a little bit of a recess before we conduct that, unless everyone's ready to proceed with that. I think that I told the media outlet that I would recess briefly to allow them to kind of reconfigure what they're doing, and so we'll be in recess for a short time until I'm informed that everyone's ready. All right? Thank you.
Yes.
Let's go ahead and bring in the defendant, Mr. Colt Gray, please. Good morning, sir. Are you Mr. Colt Gray? Am I pronouncing your first name correctly? Mr. Gray, my name is Curry Mingledorf. I'm assigned to preside over this morning's proceeding. This is your first appearance hearing. And at this hearing, I'm first going to ask you just a few questions, and then I'm going to advise you of your rights and also let you know about a preliminary hearing that's been scheduled for you. Why don't you just state your name, please? All right, you pull the microphone down, please. There you go. All right, and how old are you, Mr. Gray?
54.
And are you able to read and write and understand the English language without any difficulty?
Yes, sir.
How far did you go in school?
11th grade GED.
Okay. And I note that you have counsel seated with you at the table, you understand that you have the right to be represented by an attorney at all times for this and all future proceedings in your case?
Yes, sir.
And you understand that, of course, if you cannot afford an attorney, that the public defender will be appointed to represent you upon your request?
Yes, sir.
All right. And counsel, would you identify yourself, please, for the record?
Donna Seagraves. We are going to have new counsel assigned to Mr. Gray later today.
All right. Thank you. All right. Okay. Sorry. Just need to make sure that the system is working. And all right. So the following aren't questions that I'm going to ask. I'm just informing you of some things. You have the right to remain silent. Anything you say can be used against you at further hearings or at a trial on the charges that you're facing. For this hearing, you're not going to be questioned about facts and circumstances surrounding your charges. You are currently charged with, and you'll be provided with copies of the warrants if you don't already have them. You're currently charged with 2 counts of felony murder in the second degree. You're charged with 4 counts of felony involuntary manslaughter. You're charged with 8 counts of felony cruelty to children in the second degree. Now, for these offenses, for the felony murder counts in the second degree, felony murder in the second degree, the maximum penalty for each count is up to 30 years imprisonment. For felony involuntary manslaughter, of course, again, there are 4 counts. The maximum penalty for each of those offenses is 10 years imprisonment. For the 8 felony cruelty to children counts, the maximum penalty under the law for each of those 8 counts is 10 years imprisonment, for a maximum total possible penalty for the charges that you currently are facing of 180 years imprisonment. If you have questions about these charges, which I assume that you will, the court urges you to discuss those with your attorney. Let me inquire as to whether there's a motion for bond if Mr. Gray is moving for bond at this time.
No, sir, not at this time. We will allow alternate counsel to make that decision.
All right, thank you. All right, I also need to inform you that you have the right to an indictment by a grand jury, and you also have the right to a preliminary hearing unless you make bond or waive such a hearing. You have the right to a speedy and public trial by a judge or jury. You have the right to confront and cross-examine all witnesses. You have the right to call witnesses on your own behalf and testify in your own defense if you so choose. I want to make it clear to you, Mr. Gray, that you are presumed innocent. Your refusal to testify at any point cannot be used against you in determining whether you are guilty or not guilty. I mentioned the first appearance hearing a moment ago. That is being set for you for December 4th, 2024 at 8:30 a.m. Currently that's set to take place in the Magistrate Court of Barrow County. It could be subject to change, but I just want you to know that that is the date that we currently have. In fact, counsel, could you approach, please? I have this, let's see, I need to scratch this out. This document that discusses bond and gives the date of the preliminary hearing, and I guess I could sign that, and he can just get a copy of it. And then the warrants are attached to that. that, so, and I would like for him to sign it. Turn it over, please.
Sign right there, just so you're getting a copy of this. He is giving you a copy. He'll give you a copy of all the warrants. Do you want me to go ahead and give him his copy?
Yes, please.
And the page continues. in front of you, so you're all set on the first one. And are these his copies of the warrants?
Those are provided, and they say service copies on them, so I assume that they're for him.
Okay.
Sergeant Briscoe, do you concur with that? Is that what those copies are for?
That's the detention center.
Those are for the detention center? So he's got his own copies, or he'll have them provided? All right, so the detention center wants to hold on to those. All right, let me, and thank you, Ms. Seagraves. I want to certainly acknowledge the presence of our district attorney, Mr. Brad Smith. He's assisted by his chief assistant, Patricia Brooks. Is there anything else, counsel, that the court needs to address that I have neglected to address?
No, Your Honor.
No, sir, not at this time.
All right. I do want to thank those who are in the gallery who have an interest and who have appeared. I appreciate the decorum that has been maintained throughout this proceeding, or both of these proceedings today. And with that, this matter is adjourned.
The attorney who's going to represent you, I think his name is James Rogers. We're going to have the official later today, but he'll come and see you probably the first part of next week.
Morning. Of course she did. I have to do it. 5 and she this other time on patients.
Gentleman, Ms. Dugan,
I already did.
are the victim's family asking to be on Zoom once again?
I do not know the answer to that, Judge. I'm sorry. Let me concur. I think we should probably assume so. Let me concur.
All right, I see a tile labeled Ruth Markel.
Okay, then yes, Your Honor. Thank you.
Do you have any idea who Misha Janice is?
I do not.
The only reason I'm asking is because in the last hearing, someone joined Zoom who's doing inappropriate things. So from here, Zoom is going to be limited. If I get wind of anyone else trying to do inappropriate things in the midst of Zoom, ultimately it's just going to be, if you're here, you're here, you're not, you're not. I'll go ahead and allow all parties to make their appearances for the record.
Georgia Kappelman for the state, Your Honor. Sir Catherine Dugan from the state.
Dan Rashbaum on behalf of Mrs. Adelson, who's present. Alex Morris on behalf of Mrs. Adelson.
Very well, let's go ahead and move with the one hearing that was scheduled for today. This is the defendant's motion in limine concerning the testimony of Sergeant Corbett and the summary exhibit. Whoever's arguing the motion may proceed.
Madam Clerk, Your Honor.
You may.
Judge, I think we filed pretty detailed papers on this. So I'll quickly summarize, and then if you have any questions, I'm happy to answer anything that you have. I think it's very important to realize we're not asking that he not be allowed to testify. What we're asking for is two pieces at this hearing, and there'll probably be more during trial regarding actual pieces of his testimony. So that's the third piece. The first thing we're asking for is that he not be qualified as an expert. We don't believe, as set forth in our papers, that he's testifying to anything that meets the standard of Florida Statute 90.956. And so we don't think he meets the qualifications of an expert in what he's testifying to.
You mean 90.702?
I'm sorry, 90. Correct. We don't think he meets those qualifications. We think he is a summary witness, not an expert witness, and we think his report illustrates that. The report itself has essentially 5 components. It has emails, which are a culmination of emails that the state has taken and put in a report. Text messages, neither of which emails or text messages is he an expert on. He's just compiling them, putting them in a report. Video surveillance photos, and then it has call record summaries, which we'll get into, but takes no expertise to do the call record summaries. Florida law is pretty clear on that. As well as cell site data, but it's very limited to cell site data, especially with regards to Mrs. Adelson, who's on trial here. There's some more detailed cell site data with regards to Mr. Garcia and Mr. Rivera, but even that wouldn't qualify as expert testimony. The cell site data as to Mrs. Adelson, there really is virtually none of it. So
One question before we continue on track of the expert testimony. As it relates to items that the state can properly admit, and I'm sure that based on your pleading, there are aspects of the current PowerPoint that are disputed as being inadmissible. But for what can be properly admitted, are you also disputing that those cannot be used as a demonstrative during trial by the state in some way?
no, they can be. So in other words, there's no dispute that they can use the report as a demonstrative. There's no dispute that for the admissible items, they can put in the admissible items. So I'll give you an example. Email between Wendy Adelson and Donna Adelson. Clearly it's admissible, provided it's relevant. The ones they provided are relevant. Clearly admissible. The underlying email can be admitted, shown to the jury through an appropriate witness, if they call Wendy Adelson, for instance. Okay, so that email is admissible. But the summary of the email in the exhibit, the summary of the 1 or 2 page email in this exhibit can be shown to the jury, but it doesn't qualify as expert testimony or a proper summary exhibit to be admitted. Does that make sense what I'm saying?
It does. The only thing I would question, even concerning demonstrative, are you also saying the state cannot put the context around these various pieces of evidence?
No, they can. Right? They can make arguments just like they do in closing arguments. Right? They can show the exhibit to Corbett, Sergeant Corbett. He can put it on the screen. He can explain whatever he's going to testify to. Our argument is he's not an expert in doing that. That's our first argument. And our second argument is ultimately that 329 pages right now doesn't go back to the jury. it's a closing argument, essentially. When you look at his 329-page exhibit, and again, I'm getting a little ahead of myself, but when you look at his 329-page exhibit, it's essentially Ms. Kappelman's closing argument, okay, which we don't admit to the jury. The jury doesn't get her slides and see them in the jury room when they're deliberating. But no, of course, they're able to, provided it's admissible material in it, they're allowed to show the exhibit. They're allowed to use it as a demonstrative. They're allowed to question Sergeant Corbett. He is allowed to be a witness based on what he did. Our argument is, number one, he's not an expert, and number two, the actual exhibit is not an appropriate summary exhibit that would go back to the jury during deliberations. That's what our memo is about. And it's supported, Judge, by Florida law. So the Florida Supreme Court has held that law enforcement testimony, which merely summarizes and explains data from cell detail records, including the mapping of cell phone location data, is not expert opinion under Florida Statute 90.702, and Daubert, because it involves no scientific, technical, or other specialized skill, cites King v. State 260 SO 3D 985, Florida 2018, McMillan v. State 214 SO 3D 1274, Florida 217. The Florida Supreme Court has supported that, and also has the 11th Circuit in Batista, B-A-T-I-S-T-A, in affirming the Florida Supreme Court, where the 11th Circuit of Court of Appeals affirmed the district court's decision to admit as lay testimony an FBI agent's use of cell phone records, along with the phone company's records, of where their cell phone towers were located, to plot on a map which towers connected with which cell phones at a particular point in time. But it said it wasn't expert opinion. It said that you don't need the agent doesn't have any expertise to read the cell phone records to determine which cell tower was used at a particular time, look up the latitude and longitude of that cell tower in the company's records, and mark the intersection of the latitude and longitude on a map. That's precisely what Sergeant Corbett is doing here. It is exactly on point to what he's doing here. Also, the fact that he pulled data off of iClouds and he pulled data off of iPhones, it's not expert. Now, of course, he's able to testify to it, but it doesn't meet the standards of expert testimony. Now, moving to the second point, Judge, which is whether...
Before you move on to that, when it comes to the data pulls, because I've heard this argued, not by you, but a number of ways over the years, the first being the data pull itself is a factual issue, which I would agree. How the machine works and whether or not the data pull was in fact, it took place technically in a correct manner, that goes to more specialized information. Is there going to be any contesting of any way that the data pull was somehow not technically proper or sufficient? Because if so, at that point, now we are veering into a matter that deals with specialized information, knowledge, or expertise.
Judge, may I have one moment, please?
Go ahead.
You've stipulated to that. That's one of the things you stipulated to. All right, so we'll have to figure that out. Okay.
Judge, I don't believe it's going to be an issue. But we understand what you're talking about. If it were to become an issue, then obviously the expertise on that particular issue would be obviously subject to his qualifications, which we think he has. Okay, but at this point we don't anticipate it being an issue. We don't anticipate. There may be questions as to why he pulled it as opposed to someone else pulling it. But as far as whether it was pulled appropriately or not, we're not contesting that.
Very well. You may continue.
Okay, so Judge, if I may just move on to the second part of the argument. The second part of the argument is not dependent on the first. So whether he's an expert or not an expert, it really is an independent inquiry, the second part of the argument, which is whether ultimately whatever turns into his exhibit is demonstrative, goes back to the jury. And again, for purposes of today, unless you want to go into it, I'm not going to be talking about specific pages that we don't believe are admissible. So let's just talk about the thing as a whole, if that's okay with the court.
Go ahead.
So, Judge, this summary, and I think you've had an opportunity to view it. It's not, the first thing to understand is it's not a neutral summary. That's the first thing to understand. The second thing not that alone does not end the inquiry. It's just a fact.
Well, to that, and obviously a criminal case is different from a civil case, but all the time, in civilly litigated matters, parties will have presentations, reports, summaries prepared. The plaintiff, by nature, is adverse to the defendant. Anything that they're preparing for the jurors is going to advocate or in some way demonstrate why I should win. As it relates to this summary, the state is prepared this in anticipation of litigation to advocate their position. Why is this inappropriate?
That alone, that fact that it's not neutral, is not the determining factor. But it's one that courts would tell you to look at in deciding whether it is a summary that's appropriate to go back to the jury or whether it is more in line with a closing argument, which would not be appropriate to go back to the jury. So I start with that just because it's just as a basic factual point. I don't think it's determinative of your decision. What is determinative of your decision, though, is when you look at this summary, it's full of items. Again, we're not disputing that the items are admissible. Let me be clear on that. So the summary has, for instance, I think at last count, 30 to 40 emails. Those 30 to 40 emails, provided they survive evidentiary challenges, are admissible. But a summary is done for the purpose of taking voluminous records and synthesizing them in a way that helps the jury. That's what the statute talks about, right? And that's what the case law talks about. That's what Oloyede talks about, which is 933 F3rd 302 310 4th Circuit 2019, where it talks about how we don't send closing arguments back to the jury. That is not admissible under law. Because summaries are elevated under Rule 1006 and also Florida Statute 90.956 to the position of evidence, care must be taken to omit argumentative matter in their preparation, lest the jury believe that such matter is itself evidence of the assertion it makes. So in this document, you see a bunch of items that are not voluminous. They're one page. Rental car agreements. There's no summary needed for that. 2-page emails, 1-page emails. There's no long emails. 1-page text messages. Not necessary. And then you see call records, and you see some call summaries. Again, not voluminous materials. I wish they were, but they were limited in what the call materials were. So, Judge, our argument is that the exhibit itself can be shown. We're not arguing that it can't be shown to the jury.
As a demonstrative, but not as admitted evidence.
Admitted evidence. The underlying evidence in it that's admissible can be admitted, obviously. Now, within the summary, and I think this may be better taken up at trial or in another day, unless you want to take it up now, within the exhibit,
hold on. As to any pages that are specifically disputed as inadmissible, it's best to handle this outside of the presence of the jury, so that way it's clear what is in and what is out when all of it is ruled on.
Yeah, so I mean, we can do that at your convenience. Look, the state has still been updating it, so things may change, but we already see some pages that are either hearsay or privileged under the joint defense privilege, for instance. We already see, there's not a lot, but we already see some pages that we think are problematic, and we can take that up whenever you want. But our argument today summarizes on his characterization as an expert and either way on the document actually going back to the jury.
Let's handle that part of it then next Thursday if there are still disputes as to individual pages, so that way it can be handled and ruled upon.
Okay, thank you, Your Honor. If you don't have any questions, we'll rest on our papers.
Very well. State, you may respond.
Morning, Judge.
Good morning.
So the defense motion argues that, you don't have to be an expert in order to testify to phone evidence, and they cited the King and Gordon cases in their motion and talked about them this morning. I think it's important to consider that in both of those cases, which were post-conviction motions, where the court said that the defense was actually not ineffective for not getting their own expert, or not objecting to the witness testifying for not being an expert. The defense did not object to a non-expert law enforcement officer testifying to the cell phone evidence in that case because it was a strategic decision. The defense knew that they could cross the law enforcement officer more effectively than an expert, and the state could easily get someone more qualified had the defense objected. In Gordon, the court said that the witness from the phone company who testified would have qualified as an expert to testify to that data and been able to testify to the cell site data had there been an objection. In King, in that post-conviction evidentiary hearing, the defense put an expert on the stand who provided expert testimony on GPS and on cell phone location data. The defense expert concluded that the defendant could have been at home, not at the crime scene at the time of the murder. So in that case, there was an expert who testified to the location information from the cell phone records.
That does lead me to my first question concerning Sergeant Corbett. What exactly is he going to testify to beyond what the cell phone data history records or cell phone tower records would show? That otherwise you need him to testify through an opinion that he cannot just testify off the records themselves.
Yes, sir. So he's going to be, and I have this in just a second, but as far as the summary goes, he's not testifying as an expert to everything in the summary, but he's testifying as an expert to a large part of the summary when it comes to cell site location data and how far, who's using a handset at the time and how far the person is from the cell site location. He uses the more...
So you're saying how to interpret that data?
Yes, sir. And he uses more than just cell phone records to do that. But the cases, the Gordon and the King cases, those cases say a witness does not have to be an expert to testify to some of that information. But they're not saying that you cannot present an expert to offer an opinion on a handset's location. If that witness has the necessary training and experience, just as was done at the hearing in the King case and could have been done at the trial at the Gordon case. And Sergeant Corbett has hundreds of hours of training and experience and has offered an expert opinion well over 100 times in circuit court. The reason they don't want him to be able to declare an expert, they don't want him to be able to offer an opinion. And this is more than just a data pull of, hey, we got these cell phone records. And this is more than just, this is where the cell site locations are at any given place in Florida. This is him forming an opinion on how far a handset is from a location, who may be using the handset at the time, that you need this specialized, or that it's beneficial for the jury to hear his specialized knowledge because he's able to interpret the cell phone records to tell us that information. The defense also argues in their motion that there's basically just too much evidence in this summary, that it's more than just for phone records and some of the evidence isn't voluminous. But a summary's whole purpose is to summarize relevant evidence. Sergeant Corbett, as I said, is not offering an expert opinion on everything in the summary. He's offering an expert opinion on the interpretation of the cell phone records, the location of the handsets, who may be using the handset at the time. And there's a large part of the presentation that are those things, but there's a lot more information in the summary, like surveillance video from Premier Gym, a traffic ticket received by the suspect, a car rental agreement, that maybe those things individually aren't voluminous, but they're all material to the presentation and material to his opinions because he's using them to provide an opinion on who had the handset and where the handset was at the time. For example, if a certain suspect's phone is communicating with a cell site that's consistent with like a car rental company, an expert may be able to better determine who was using the handset at the time and confirm their actual location and confirm the reliability of the cell site information. If we're able to see that, well, that person actually got a rental agreement at the time, they got a traffic ticket shortly after the car was rented, all of those things help him form his opinions and determine that. The defense says, this is a closing argument. The information that he looked at in this case, there is so much digital evidence that it is very all-encompassing. However, there's not what's in the presentation is not. It's all data. It's messages. It's emails. It's different business records and cell phone records that we received that helped inform those opinions. They talked about the 30 or 40 emails. When I'm handing them over the things that I may use in my presentation, I'm trying to be as thorough as possible. I don't want them to have less information than I may use. I don't intend to use all 30 or 40 emails. I don't intend to have Sergeant Corbett sit up there and read all of those. But I wanted to send them all of the ones that I may use as far as just these are what was found in these different accounts. This was and asking him, hey, did law enforcement find some evidence of motive that caused him to look into these people? Yes, X, Y, and Z were found. Maybe spend 3 minutes to 5 minutes on that and move on to the next thing.
As to that point, and I believe the defense's motion hits on this as well, for what you have asked Sergeant Corbett to add to this, is that in fact his opinion?
So the defense motion attacks that, the prosecutor is ultimately deciding what's going into the presentation. Maybe that's what you're referring to.
Yes.
But Sergeant Corbett's job is to pull information from these devices, interpret that data from the cell phone records. He's not investigating or prosecuting the case. In the investigative phase, he has to rely on the investigator to let him know what he's looking for, what this proverbial needle in the haystack is, whether he's wondering it exists. And Sergeant Corbett's then looking through the records to see if there is one, and then if there is one, including it and letting them know. Sergeant Corbett doesn't know exactly what the prosecution wants to present at trial. I talk to him about what the records show. I ask questions. He looks for answers. He lets me know what the data says. And then I'll say, yeah, can you put that in there? I think that's important. He's not the one talking to witnesses. I may talk to a witness. They tell me a certain event occurred. Then I go back to Sergeant Corbett and say, hey, is there any evidence of X happening? And he lets me know that may corroborate what the witness says, and then we're able to put it in there. And I'm not able to get that information in any other way because he's the person that's looking in these cell phone records and can let us know whether that evidence is corroborated or not, and can provide an opinion on what the data shows, where that handset was at the time, how far they were from the tower at the time, things that may corroborate witness testimony or appear in the cell phone records that I wouldn't be able to see or know on my own. The defense motion also argues that the summary isn't admissible, but summaries are admissible. That's the whole point in using them, and there's no case law that I know of that says otherwise, that a summary isn't admissible and has to only be used as a demonstrative, and the defense doesn't cite any either. The defense has specific objections to certain slides because of hearsay or privilege or other things, which I'm ready to discuss at any time the court is. But as far as the summary not being admissible, there's no case law that I know of as to that, and the defense hasn't cited any either. That's all I have.
Very well. One question about the document itself. And I think this is really what goes to the heart of the defense's motion about the summary. If you're taking, say, thousands of pages of documents and you reduce them to, let's give it an arbitrary number, a 25-page report, you have synthesized the larger to the smaller into something that is digestible for the jury to use in making their decision. That, or at least in quoting their position, is not argumentative. Some of these things are more or less a part of the state's summary, at least as it stands right now. It's showing corroboration of other evidence. Is that in fact a summary in the sense that the statute defines a summary?
Yes, sir. I mean, this is the things that may corroborate other evidence, though, help this expert form his opinion. As the example I gave with the traffic ticket and the rental agreement, he's able to, from the phone records, say this phone is consistent with this cell site at the time. They may be this far from there, but as far as showing who has the handset at the time, like who's talking on it, and how far they are from it, it's all of those other evidence that helps him form his opinion.
Very well, thank you. Brief response, if you have one.
Really brief, Your Honor, and I just want to make this clear, and I think you understand our position perfectly. We're not arguing that summaries are not admissible. We're arguing that this is in the proper summary. That's the argument. We don't make an argument in our papers that summaries are not admissible. We're saying that this document doesn't meet the foundations of the Florida statute as a proper summary. Again, they're taking particular points, but these are not voluminous documents that they're now summarizing. So there's only one voluminous document that they're summarizing in this entire presentation, and that's how they got originally to Harvey Adelson's phone number, where they had data that would go to the ceiling. If they wanted to do a summary exhibit on that piece, it might be allowed. But everything else is not voluminous materials. It's a closing argument. To allow them to put that document to the jury would essentially be the same as saying, you know what, Ms. Kappelman, Ms. Dugan, when you do your closing, the PowerPoint that you do, that should go back to the jury too. Because it's essentially the same thing, Your Honor. There's no difference. That's all I have, Your Honor.
Right, concerning this motion, I'm prepared to rule on part of it today. As to whether or not Sergeant Corbett can be properly qualified as an expert witness, I will find if Sergeant Corbett is capable of testifying to the interpretation of the records that go beyond just merely where the towers are, what was pinging, and what the phone records show, that would go to scientific or technical expertise in which he is properly able to give an opinion. As to the summary itself, and I do not want to belabor this point, but I do believe I am going to need to hear from Sergeant Corbett specifically as to how he put this together, and his opinion was informed by the information that is in the summary before I can rule on it. Otherwise, I agree with the defense position. This is proper as a demonstrative, but to admit it as evidence, I'm going to need to hear more. We'll have part 2 then, in which Sergeant Corbett can testify concerning how the summary was created and how his opinions were formed by the evidence that are within the summary, after we have the docket sounding next week. As to another matter in which I am prepared to rule on at this point, concerning the defendant's motion in limine, concerning testimony from Wendy Adelson as to the storyline of her book and also changing the names of the children, I will permit the state to use this information for impeachment, depending on what is developed during the examination of Ms. Adelson. As to the other matters concerning her testimony, that has already been ruled upon. Has the state also decided which jailhouse recordings you are intending to use for evidence? Because I did need to review those.
Yes, sir. As of right now, we do not have any jailhouse recordings that we intend to introduce that feature Mr. Adelson, which is what the defense was objecting to. So that's why we have not sent any to Your Honor. May I clarify what you just said about the name changes?
Go ahead.
You said it could be used for impeachment. She admits that point, or has previously. Would I be permitted to inquire about that area?
As it relates to any prior testimony she's given on the subject, you may inquire as to that.
Thank you.
Very well. I believe still outstanding.
Judge, I'm sorry.
Go ahead.
I just want to make sure I understand now. So our motion was to prevent them from inquiring as to the name changes. So in other words, our motion was Ms. Kappelman or Ms. Dugan can't ask her the question, did you change the kids' names? That was what our motion was. So I'm just not sure the ruling. Can they ask that question?
Well, on that particular point, what is being offered for Ms. Kappelman?
For motive, Judge.
As it goes to motive, I will permit it for that reason, or also impeachment, depending on what comes out. Motive and bias are equally available for both parties to explore. All right. As to the state's motion in limine, I believe there is also one other outstanding item to be addressed concerning Luis Rivera's gang affiliation. As to this particular point, and I've researched this further, Mr. Rashbaum, as to the name of the organization, I'm really failing to gather why hearing I was threatened by a gang member versus I was threatened by a Latin King member is going to in some way create a greater credibility in front of the jury for the narrative that you wish to weave. I will permit Ms. Adelson, if she testifies, that she acted in accordance with being threatened by a gang member. The specific name of the gang, I don't believe in any way is going to assist the trier of fact in terms of assessing her story, whether it's credible or not. They will make their determination if they believe this testimony. I believe that was the only other outstanding matter of the state's motion in limine. As to Jeff Lacoste, I have not finished my research yet on that matter, but I will rule on it before we start with any selection of the jury. Do the parties have any other matters that we need to address this morning?
Yes, sir, just a second. Judge, in contemplation, like a planning when to start evidence, can we all agree that we would not start the presentation of witnesses until Friday, the first Friday?
Assuming that we have the jury selected by Thursday.
Yes, sir.
Well, that would probably be appropriate. Does the defense have a position concerning this?
You have 1 moment, Your Honor.
Go ahead.
That's fine, Your Honor.
Very well. Assuming we have a jury by Thursday afternoon, we would start with the case on Friday. Well, would the parties be able to go into their openings, assuming there's enough time Thursday afternoon?
Yes, sir.
Mr. Rushbaum? Very well. If we have enough time, then after we have the jury selected and sworn, we would give openings and then launch into the testimony from there with all of the witnesses. Does the state have an idea, at least in terms of days, how long you think the case in chief will last?
I think 6 to 7 for our case in chief, Judge.
All right. Does the defense have any idea at this point?
I would say it depends, obviously, but I would think 2 days.
Very well. No one's going to be held fast and firm to this. I'm just asking for an estimate. One other matter to address with the defendant directly before we finish this morning. Ms. Adelson, next week we are going to have your final pretrial. That is typically the hearing in which I inquire of both parties if they are in fact ready to go to trial, if any continuances are necessary, and also information concerning plea offers. As I stated to you at a previous hearing, I do not prod people to take pleas. However, if you wish to consider a plea offer from the state, the time is rapidly coming for you to make that decision as to whether you desire to entertain any plea offer or not. If you want your counsel to provide an offer to the state, also the time is coming very close to a conclusion for them to do that as well. I'm not going to prod you either way, but I want you to be mindful of the fact, once we begin jury selection and the denier is sworn, that means trial has started. From there, basically, because of count one, if you are convicted as charged, my hands will be tied concerning any sentencing on that matter. Your attorneys will have further discussion with you concerning this, but if you are considering anything at all, you need to make a decision on this quickly. Do you understand where I'm coming from?
Yes, I do.
Very well. We are in recess. I will see everyone next week at 9 o'clock, September 12th.
Judge,
Yes, sir.
maybe briefly go sidebar.
Yes.
Sorry, I get it. I understand. Okay, that's your job. Sorry.
All right. That is the conclusion of the hearing for today. Have a good Friday, everyone. We're in recess.
Thank you, Judge. Could you zoom in? All right. Mr. Sledge, would you read the first post that you made?
It said I woke up like this.
And then what's the next one?
My baby.
And are you responding to someone, tagging someone, saying that?
Yeah, I said thank you, sis.
All right. And is that at K2 Success that you're telling that it's your baby?
Yeah, it do. It say thank you, sis.
All right. And what's the next line?
Such a good father. Keep up the good work, bro.
And then who is that person talking
It
to?
said thank you, sis.
Is that person writing to at YSL_Tunk?
Yes.
And is that Kahenti, Kahenti, that made that post?
Yes.
In response, do you then tell at Kahenti, thanks, sis?
Yes.
And then do you tell someone else thank you?
Yes.
Does MDBNELL congratulate at YSL_Tunk?
Yes.
After that, does Pizzle.dope ask, say slime, what's your math?
That's a number thing. I don't know, but I see the pound sign number for a number
Do
on
you
my
see?
side.
Okay.
If you pay,
Right here, do you see say slime, what's your math?
oh, okay. I see it on now, but it don't show right here.
You don't see say slime, what's your math?
Oh, okay, right there. Okay.
Okay,
I was looking right there.
that's okay. And then, do you respond to at Pixel effing baby, what's the move, slime?
Yes.
And then does Pixel.dope respond, trying to see now, send your number. They
Yes.
use a hashtag.
Yes.
And then do you respond to @PixelFNBaby 404-662-8935?
Yes, but yes, go ahead. Yes, I respond to that.
You're able to say
No,
whatever you need to
go.
explain.
I respond to that.
Okay. And was this post made around the time that your child was born?
Yes.
All right. Now, can you tell us when your child was born?
I just remember December, around December or something.
December, what year?
2014, I want to say.
Thank you. Yesterday, we talked about what happened on January the 10th of 2015. Has any part of what you told the jury yesterday changed regarding what you recall happening January 10th, 2015, after you learned about the murder of Donovan Thomas?
You gotta refresh my memory. I don't remember.
Do you remember what happened after you learned about the murder of Donovan Thomas?
No, could you refresh my memory?
So is it your testimony you do not remember what you told the jury yesterday?
I'm not saying that. I'm just saying I don't remember right now. If you could show me, then I can. I don't remember right now.
Did you testify yesterday that you got a call around 10-something p.m. or you got a DM
Yes.
that indicated you and someone else were responsible for the murder of Donovan Thomas?
Yes.
Do you now remember what you did after you got that DM?
No, I don't think I said. I remember saying that I went to Mr. Jeffrey's house.
And do you remember what you said or who you said was at Mr. Jeffrey's house?
Yeah, whoever. I don't know if he's the cameraman or he just do the videos. I'm not for sure about that.
All right. And is it still your recollection that only Mr. Bean, you, your child's mother, your child, are the people that you recall being at that house on 10th Street?
I told you it was other people there, but I don't know the other people.
Did you also testify that none of the defendants in this courtroom were there?
I said, I don't remember saying none of them. Now, that's what I said.
Okay. And thank you for clarifying. You said that yesterday. Is that still your memory today?
If you have anything to refresh my memory, Ms. Love, you can show me and then.
I appreciate that.
But I don't remember.
Okay, so that's still your memory today.
Yeah, that's my memory too. I don't remember.
And what about when you went to Mr. Williams' second residence? Today, do you have any further memory about who all was at that residence?
No, if you have anything that can refresh my memory, you can show it to me, but I don't remember.
Okay. And do you not remember any of the defendants in the courtroom here being at that residence?
I don't remember.
Objection asked and answered.
Okay. Do you remember being at Rice Street in November of 2015?
November, yes.
And while you were at Rice Street in November of 2015, do you remember calling and speaking with your child's mother at various times?
I talked to her a lot of times, so you have to refresh my memory.
Would showing you a rough transcript of that call refresh your memory about what was said during, or let me ask you this, do you recall talking to your child's mother on November 19th, 2015 at 8:03 p.m.?
I don't remember the dates, man, love. I talk to her most every day, so I don't remember the exact dates.
Would showing you a rough transcript of a call refresh your memory?
Maybe if you show it to me, yeah.
Right. Your Honor, we will label this states 448 Yankee, and it will not be for the purposes of admitting for the jury, just to refresh his recollection. And Your Honor, yes, I was going to ask if the defense could look at it first.
Yes. is set. Yes. There's one more. Well, I didn't think it was going to take this long.
Your Honor, Mr. Sledge asked if he could have a moment to read that with his attorney.
All right.
He said he doesn't read as fast as I do.
Okay. Well, if y'all want to go back to the jury room, you can, but I doubt if it's going to be that much longer. And by the time you get back there, I'll be calling you back out again.
Your Honor, may we approach with a member of the defense about a correlated matter?
Sure.
Do I start, Your Honor?
Yeah.
Trying to be pro.
I think that's because I have this back here. Go ahead.
Trying to be proactive, Your Honor, based on our outside of the jury conference earlier this morning regarding that jail call. We went ahead and clipped the portion that the court determined could be relevant and had that sent over to the court and to counsel in the event that it became necessary to play simply that snippet. we sent that so that if there was any disagreement that was the portion the court acknowledged may be relevant, counsel could let us know. We were offering it at this time. I don't know whether the transcript we've provided is going to refresh Mr. Sledge's memory or not. He's having a conversation with his attorney.
Okay.
I was under the impression that we litigated this morning and that the state, and then you asked the state to play it, and the clip they played was talking about what Shannon's paid lawyer said.
Right. I don't think that's this. I think what she has just sent us is that first part we talked about, that is the transcript that he's looking at now.
Okay. I don't know how that could be 28 seconds, but
I don't think it should be 28 seconds either, so I'd like for us to...
Can we play it for the court?
The whole situation, whoever witness number one is, they try to know it's he. Cause he say, you remember when we talked on the phone, he's like, boy, you ain't know nothing about it. You was in the blind. Mm-hmm. They told them folks this. After Lud got killed, all of them met up together and went down old boy house. Them made that work. That's how you know it's he.
Them folks, after Nut got killed, again, we're backdooring the fact that D said something to the police that's problematic. If Mr. Zachary takes a stand, I will deal with it, and I will cross-examine him, and it won't be a problem anymore. But I don't want there to be any insinuations, any references, any reference to D telling on people until he takes the stand. And so I don't know why we have to get into what Lil D told them folks to get the fact that he was at a condo.
Do you have the transcript, or does he have, Mr. Sledge have it?
Mr. Sledge has one copy. I have one.
And if Mr. Sledge needs to hear that outside of the presence of the jury to get context to understand what he said previously, I don't have a problem with that. I just don't want the jury to be hearing Mr. Sledge's phone calls to his girlfriend about what other people told the police. Right.
I think you could accomplish the same thing if you just cut out the witness one because part. I mean, what you're asserting that you want to get in is, I heard that he said these things, and we know it's him because of exactly what he's saying. So we don't need the witness one part for that. So
we will have Mr. Makins take out witness one.
And just start with he say.
Yes, Your Honor.
And
I don't have the transcript in front of me. I don't have the call memorized, but I did hear.
We can play it again.
He's telling them folk what he told them folks.
Yeah.
The whole point of this is just, was Mr. Zachary at the condo that night or not? And I really don't care what the answer is. All what I don't want is a bunch of references to what was said at a prelim, and D is telling these folks this and that.
Nobody's gonna know who them folks is from this.
Well, them folks is
Them folks could be anybody.
Your Honor,
Folks could be anybody.
Respectfully, Your Honor, them folks in the street is police. That's slang for the police, and I believe the jurors are going to be able to put that together.
Well, I don't know whether they will or not, but that's what he said.
Well, I understand that's what he said, but I don't believe that just because he said it, it's admissible. Him talking about what Lil D did, respectfully. If Lil D takes a stand, we'll deal with it.
Okay, well, maybe he'll just remember that Zachary was there after all.
And Your Honor, again, we gave that to him to refresh his memory about who all was there. What I started the questioning with today was, do you have any different
I
memories?
understand. I was here. All right, I'm going to hand this back to you. But if he's presented with the transcript and he claims to still have no memory, then I'm going to permit this in as a prior inconsistent statement. Yes.
This once, but I'm going to say it again. I would suggest someone just play Mr. Sledge's recording and then see if that refreshes his recollection outside the presence of the jury.
I asked him, did he want to? I asked him, do you want me to play it for you? You want to take the transcript? He said, I just like to read it. I just need more time. That's what just happened back there in the presence of his lawyer and chief investigator, Mom. Anybody want to ask?
Okay, can
you what?
Can I go talk to the witness and ask if he wants to hear the recording?
I appreciate it. The witness would be allowed to talk to his own attorneys.
Only the state gets to talk to him. Okay.
Well, you are the one, Mr. Shard, in fairness, that asked for a bench conference
You're right.
and suggested that Mr. Sledge be apprised and that his lawyer be apprised as to maybe what should and shouldn't be said from that transcript. And that is why Ms. Love went out and gave them that transcript.
And Your Honor, I was under the impression that this whole thing about the call had been settled. Apparently, I was wrong about that. But if he needs to listen to the call to refresh his recollection, I don't have a problem. I'm just
Well, you know what? If he comes in and he says, yeah, that still doesn't help me, but if I could hear myself say it, then maybe that would, then we'll take it from there.
Okay. Thank you.
Do we think maybe he's ready, or is somebody going to let us know? Or
I told him to come back in, but I'll send someone out to see.
Or, I mean, his co-counsel could do it. She's still here. That way there's no kind of, one side gets to see Mr. Wright more often than the other side. You can go ahead and take that screen share down for now, since we might not get to that. Yes. 5 more minutes. Anybody else need to use the bathroom? Okay, can you do it quickly, because I don't want it to turn into another 20-minute recess. We've had about, 5 minutes of actual trial time today so far?
There was no objection to the plea video, right?
Hmm?
There was not an objection to the plea video, right?
No one has voiced one. I mean, other than they don't think it's a prior inconsistent statement, and I ruled on that. get the jury back.
We're ready.
Yes, sir. I've instructed him, may I ask his counsel?
You can do it right now while we're waiting on the jury.
Mr. Sledge, have you had enough?
Hang on. We're waiting on a juror.
I'm sorry.
That's why we're all
Y'all
still
were waiting
standing.
on me. I'm so sorry.
All right. Even Ms.
My
Love wants to
apologies.
move the case a little bit now.
I thought they were waiting on me. I'm sorry. I feel a little self-conscious. Mr. Sledge, have you had enough time to speak with your attorney and to review the exhibit labeled States 448 Yankee that I gave to you to refresh your memory?
Yes.
All right. And is the attorney with whom you reviewed that document the same one that you had on December 28, 2022?
Yes.
Were you able to ask questions and gain answers to every question that you had regarding this document?
Yes.
All right. Does reviewing States Exhibit 448 Yankee refresh your memory about a phone call that you had with your girlfriend, with your child's mom, on November 19, 2015?
Yes.
All right. Your Honor, I'm going to place this here as not admitted for the purposes of the record.
All right.
Mr. Sledge, having read States 448, do you have any more memory about who all was at Mr. Williams' condo, or with whom you might have met at the condo after Donovan Thomas was killed?
Could you repeat that, Ms. Love? Repeat it one more time.
Yes, sir. Having refreshed your memory about the phone call that you had with your child's mother,
Yes.
do you have any more memories about who all you met up with after Donovan Thomas was killed?
Yes, I think.
All right. When you say you think, who is it that you think you remember you met up with after Donovan Thomas was killed?
Who I met up with, or who I was at the condo. You losing me right now.
Let's go with the way you first said it, or the last said it. Who all was at the condo?
I still don't remember who I was there with. I'm trying to think. I seen the paper, but I didn't see any name really that was on the docket saying who was all there.
Do you remember whether Quindarius Zachary was there?
I think Quindarius Zachary was there when I got there.
Do you remember whether Shannon Stillwell was there?
I still don't remember if Shannon Stillwell was there because I didn't see him personally with my eyes, so I still don't remember if he was there or not.
Do you remember whether Diamante Kendrick was there?
No, I think Mr. Kendrick was not there when I got there.
And when you say you did not see Shannon Stillwell with your eyes, is your testimony today you know for a fact that you didn't see Shannon Stillwell or that you don't recall?
I don't recall. When I got there, I didn't see Shannon Stillwell there. When I first got there. That's what I'm saying.
At any point, were you, Shannon Stillwell, Diamante Kendrick, Quindarius Zachary, Defendant Williams, in a room at one of his condos the night Donovan Thomas got murdered?
I think we was. I think, yes.
Which one? Which condo?
Not the first one.
The second condo?
Yes.
All right. What were y'all doing?
Nothing. Mr. Williams getting himself together.
At what point did, and let me back up and ask you this. Would you characterize your being there as y'all all meeting up at that house?
I don't think we all arrived at the same time.
That's not what I asked. Would you characterize you all being there as y'all all meeting up at the house?
Yes.
All right. And what purpose did you all meet up at the house for?
They was going to the show and the video shoot with him. From my understanding.
Were you working as head of security for Defendant Williams at that time?
No, I don't think so.
And Kenneth Copeland, was he also one of the persons that met up with you, Shannon Stillwell, Diamante Kendrick, Quindarius Zachary, and Defendant Williams at Defendant Williams' condo?
Yes, he was there.
Okay. He was there and he was one of the ones y'all met up with. Is that what you're saying?
Yeah, he came down to the condo.
All right. Now, what did y'all talk about at the condo when y'all all met up?
I don't basically remember the conversation that we was having, but I don't remember the conversation. I'm going to say that.
Is it still your testimony that you went to Defendant Williams' condo solely because you got a DM accusing you of Donovan Thomas's murder?
Yes, that's one of the reasons. That's the reason, yes.
Was there any other reason?
I don't remember. If you have anything that can refresh my memory, you can show me, but I don't remember no other reason why.
That's the only reason that you remember today? Okay.
Yes.
Given that that is the only reason you can think of that you went to Defendant Williams' condo, did you talk about the fact that you were, one, that Donovan Thomas had been murdered, and two, you were one of the ones accused of Donovan Thomas's murder.
Sustained.
Thank you. Did you talk about with the people you met up with the fact that Donovan Thomas had been murdered?
Yes.
All right. Now, about what time did you all meet up at Defendant Williams' second location, his other condo?
I don't remember the time.
Do you recall whether it was before or after midnight?
No, I don't remember.
Based on what you said yesterday, is it safe to say it was definitely after 10 o'clock p.m.?
Yeah, it was after 10 o'clock, if I'm not mistaken.
All right. Do you remember how long you talked about Donovan Thomas's murder with the people that you met up with?
It couldn't have been too long because I ended up dropping Copeland off, so I don't remember how long it exactly was.
What was the atmosphere in the room while you all talked about Donovan Thomas's murder?
What you mean, atmosphere? Could you explain that to me?
I can. How did you bring up Donovan Thomas? Well, who brought up Donovan Thomas's murder when you all met up?
I already had spoke about it to Mr. Williams.
Right.
So I don't know who started the conversation at the second location.
Do you remember what the conversation was?
I just know the conversation with me and Kenny Copeland was the one responsible for it.
And was there anything said by anybody else that you remember?
Not really. I just remember Mr. Williams telling me that we ain't had nothing to do with it. Go down now.
Who is the we?
Me and Kenny Copeland.
Okay. And do you know how it is that Mr. Williams is able to tell you that you all don't have anything to do with it?
He wasn't directly like trying to tell us what to do. He just was basically saying, don't go to the show and go down there and clear our line.
Okay. Now, to your knowledge, did Kenneth Copeland go to Miami?
I don't know. I think he called me and told me he was in Miami, but I don't personally know, was he in Miami.
And is it your testimony that you didn't go to the show because, well, you wanted to stay and make sure your family was safe?
Yes.
All right. But is it also fair to say that you weren't trying to clear your name? You did not go to the show? Did you? I'll rephrase. Did you stay back from the show in order to clear your name?
Sustained.
Did you make any efforts to clear your name?
Sustained.
Your Honor, I'm not suggesting the answer. I'm just asking one that's yes or no.
Ask it a different way.
Yes, Your Honor. Did you take Mr. Williams' advice that you say he gave?
Sustained.
What did you do after you were told to not go to the show and clear your name?
I dropped Copeland off and I went on about my business.
Do you make or recall anything else anyone else in that room said about the murder of Donovan Thomas?
Objection asked and answered.
I'm asking if he recalls anything else. He seemed to remember something.
Go ahead.
Do you recall anything else anyone else in that room said about the murder of Donovan Thomas?
No.
After you dropped Mr. Copeland off, did you ever go back to the condo that night?
We talked about this yesterday, Miss Love. I told you I went to the hotel room.
I understand. Did you leave the hotel at any time and go back to the condo?
No.
Did you see either Defendant Williams? We'll start with him. Did you see Defendant Williams any more before he left for Miami?
You said that night?
Between the time you said you left his condo and the time that he left for Miami, did you see him at any other time?
No.
Did you see Defendant Stillwell at any time after you left Defendant Williams' condo?
No, Ms. Love.
Do you know whether Defendant Stillwell went to Miami?
No, I don't know that neither.
Do you know whether Defendant Kendrick went to Miami?
Well, I think Mr. Kendrick will going because he's supposed to be in the video or something like that, if I'm not mistaken. He was going to help perform that night.
Do you know whether he went?
I don't know personally because I didn't see it, so I can't say personally that he went.
Do you know whether Mr. Zachary went to Miami?
No.
Did you speak with Mr. Williams at any time that he was purportedly in Miami?
I think he called and checked on me. I'm not for sure. I don't remember that. I think he called and checked on me, but I don't remember.
Did you speak with Kenneth Copeland at any time that he was in Miami?
Well, he told me him, his daughter, and himself or something went down there, if I'm mistaken.
Is that a yes?
Yes, I guess yes.
Did you speak with Defendant Stillwell at any time during a point where he was in Miami?
No.
Did you speak with Defendant Kendrick at any time while he was purportedly in Miami?
No.
Now, when you spoke with these gentlemen that you love that are YSL members, did you always talk with them either in person or on a telephone line, or did you have any other ways that you communicated with them?
We never really talked on the phone that much. Me and Mr. Stillwell probably talked on the phone more than anybody.
And do you count FaceTime as talking on the phone?
Yes.
All right. How often would you say that you FaceTimed with Kenneth Copeland?
I can't answer. I don't know.
Did you FaceTime with Kenneth Copeland before he met with you at Defendant Williams' condo?
I don't recall.
Did you FaceTime with Defendant Williams before you went to his condo?
I don't recall. If you had anything to refresh my memory, you can refresh my memory, but I don't recall of talking to Mr. Williams before I went down to his condo.
What about Defendant Stillwell? Did you FaceTime with him before y'all met up at the condo?
No.
Did you FaceTime with Defendant Kendrick before y'all met up at the condo?
No.
Are you able to give us just a rough estimation of how frequently you spoke with Defendant Williams on FaceTime?
I can't give you that. I don't recall.
Did you, between the time that photograph in 425 Yankee was posted, so around December 2014, and January 10th, 2015, was that the same number that you would have used and FaceTimed with?
I don't know, Ms. Love. Okay. I can't answer that question. I don't know. I don't recall that. I don't know.
Okay. Are you able to say with any degree of certainty about how often you FaceTime with Defendant Stillwell, since you said that's who you talk with the most?
We used to FaceTime a lot, so.
And the jury, and I don't know what a lot means for you, so could you please tell them what that means?
I can't give you a number of how much we FaceTime. I can't give you that number.
And thank you. I don't need a specific number. Was it every day?
I say yes, probably yes.
Was it multiple times a day or just once a day?
We talked like big brothers, little brothers, so I don't know how many times a day that me and him talked on the phone, but we talked a lot on the phone every day.
Defendant Williams and you, how often did y'all talk on FaceTime?
And then Mr. Williams didn't talk on the phone as much as me and Mr. Stillwell did.
All right. Your Honor, at this time, I believe that the instruction that the court has that should precede what will be marked as State's Exhibit 442Y that we have sent would be appropriately read.
All right, so this is going to be about his plea in this case. Okay.
Yes. In this case.
All right. So I'm going to, again, instruct y'all. And this time, everything I'm going to say is going to be applicable to this plea in this 2022 case. All right. So you are about to hear, and you actually have heard evidence that this witness, who was a co-defendant in this case, has pled guilty to some of the charges in this indictment. I caution you that the co-defendant's guilty plea conviction itself is only admitted for a limited purpose. That guilty plea is an admission by this witness only that he committed the criminal acts to which he pled. You are not to consider this co-defendant witness's guilty plea as evidence that any other defendant is guilty of committing any of the criminal acts alleged against them in this indictment. Each defendant is entitled to have the issue of his guilt determined solely on the basis of the evidence against him and not on whether another person has been convicted of the same charges with which the defendant is accused. If you find that the co-defendant witness provided testimony on the stand that is inconsistent with his guilty plea admissions, and they are going to be admissions in this case. This wasn't an Alfred plea. This was a regular guilty plea. You may consider the witness's prior inconsistent statement, that is his guilty plea admissions, including to the allegations in the charges to which he pled guilty, as substantive evidence, which you may consider against any defendant currently on trial for whatever bearing it may have to the issues on trial.
Thank you, Judge. And we are going to play that. I wanted to ask Mr. Sledge a few more questions. Mr. Sledge, yesterday, you, am I correct that you testified that you know of an Antonio Sumlin?
Yeah, I know of him.
Okay. And did you testify that that's the person that you called Obama?
You never asked me, did I call him Obama? Not.
Okay. Did you call him Obama?
Yes.
All right. And how well would you say you know him? You said you know of him. How well?
Yeah, I used to see him around, but me and him never really hung out together.
To your knowledge, did he ever claim YSL?
Yes, I heard, yes.
Okay. And when is the last time that you talked with Obama?
I don't know, Ms. Love.
Did you talk with him in 2022?
Yes, probably. Yeah, I probably talked to him in 2022.
Do you know how often? Generally speaking, I don't need a
No,
exact number.
when I seen him, I talked to him.
Okay. Did you ever FaceTime with him?
No, I never been on the phone with him.
All right. Was the last time that you saw him in 2022?
Yeah, in person.
Okay. And do you recall if you ever spoke with him around April 2022?
April 2022?
Yes, sir.
No, I don't recall that.
Do you recall speaking with him around the time that this indictment came out?
I don't remember talking to him when the indictment came out.
Okay. Did you ever share any bills with Obama?
What bills? What kind of bills?
Any bills. I don't even care what kind. Any kind of bills with Antonio Sumlin.
What you mean by bills? Could you be more specific? I'm asking you to be more specific.
Money that you owe to somebody else.
No, I don't recall that. I don't recall that.
Did you ever have to pay any rent with Mr. Sumlin in 2022?
Mr. Sumlin never paid any rent with me.
Did you ever have to pay any with him?
No.
Do you know of anyone else within YSL who is referred to as Moncton?
No.
Have you ever had any reason to charge money at a door for a light bill?
Not I know. He never gave me no money for no light bill.
That's not what I asked. Have you, Mr. Sledge, ever had any reason to charge money at a door for a light bill?
No, overruled. Go ahead.
Could you repeat it?
Have you, Mr. Sledge, ever had any reason to charge money at a door for a light bill?
I don't recall. I don't remember, Ms. Love, but I know if you came to my house and stayed for weeks and months, eventually I want some money for you staying there.
I imagine so. Have you ever had any I take it back. Have you ever had any reason to charge money at a door along with Mr. Sumlin for a light bill?
You already asked that question, Ms. Love.
I'm going to object to relevance at this point.
Your Honor, I have a very good faith basis for asking this question.
Okay. Well, you're asking him, basically, has he ever charged money at a door for a light bill? Charged anybody money at a door for a light bill, right? Just maybe ask that and then.
Yes. Yes.
Because if he has no recollection, then he has no recollection whether he was with himself or somebody else. So if you want to make sure that he understands the entire universe of people, have you ever charged them? Go ahead and ask that. But then if he doesn't recall, let's move on.
Thank you. Have you ever been upset that people were hanging out with you or at you and a spot you may have shared with Mr. Sumlin and not paid bills?
I didn't share with him. He just probably stayed a couple of nights, and when the bill came, I told him to give me money on the bill. That ain't.
Okay. And when you say stayed a couple of nights, where would it have been that he stayed?
He probably stayed in my room because I went home.
Okay. And was that your room on Boulevard or somewhere else?
Somewhere else.
All right. Was it a house that you lived at?
I stayed there when I wanted to.
What street was that house on?
I think it was off Brown Mill. I'm not for sure. I think it was off Brown Mill, though. I'm not for sure.
Did you have a nickname for that house?
No, I didn't have a nickname for no house.
To your knowledge, did anyone ever call that house the Web?
I never hung it. I never been there when they called it the Web.
Do you know of a place called the Web?
I heard of it.
Do you know where it is?
It was off Brown Mill somewhere, but I never been to it. I just knew it was off Brown Mill.
Have you ever seen it?
I didn't know exactly what house it was whenever they was calling the Web, but I never been to it at that time, so I don't know.
Who is the they that you're referring to that called it the Web?
The streets. I heard people like at the gas station, I'm about to go to the Web. So I don't know.
Were those people YSL?
I guess.
Did you ever hear anybody other than YSL members talk about going to the Web?
Yes, I don't hear females say they was going to the Web.
All right. Do you know or have any idea how far the Web was from the place you said that you were at off Browns Mill Road?
No, I don't know exactly.
Do you know the last time that you talked to Kenneth Copeland?
I can't tell you the last time I talked to Kenneth Copeland.
Do you recall whether you talked to him in 2022?
I don't recall.
Do you remember talking to Kenneth Copeland at all while Kenneth Copeland was in prison around that time? That time being 2022.
I don't know if I talked to Kenny Copeland in that time. I'm not for sure, my lord. I don't want to say the wrong thing, so I'm not for sure.
Right today, you don't remember?
Yeah, I don't remember. Right.
Okay.
So.
Do you remember whether you talked to Demekion Garlington?
When?
When was the last time you recall talking to Demekion Garlington?
I'd probably say 2022.
Okay. Did you ever talk to Kenneth Copeland or Demekion Garlington, either of them, about a RICO indictment?
You said that I ever talked to them about it?
Yes, sir.
I don't remember, so if you have anything, you can refresh my memory. Yeah.
Do you have any memory of having conversations about a potential RICO indictment before this indictment or its predecessor was ever brought forward?
I don't remember, Ms. Love. I'm being honest with you. I don't remember.
Thank you. I appreciate that. Your Honor, at this time, the state asks permission to publish 442 Yankee. I'm sorry. We tender 442 Yankee as evidence.
All right, that is admitted and you may publish.
Thank you, Judge.
We're on the record in the matter of the state of Georgia versus Antonio Sledge in 22 SC 183572. Good afternoon, Mr. Wright.
Good afternoon, Judge.
Good afternoon, Mr. Sledge.
Good afternoon, Your Honor.
And good afternoon, counsels Love and Hilton. Okay, counsels, I understand this is supposed to be a negotiated plea. Is that correct?
That's correct, Your Honor.
Yes, Judge.
All right, Mr. Sledge, can I get you to raise your right hand as best you're able?
Yes.
Do you solemnly swear or affirm that the evidence you should give in the matter now in hearing should be the truth, the whole truth, nothing but the truth, so help you God or so firm?
Yes, I do.
All right, you put your hand down, sir.
Mr. Sledge, please state your true, correct, and legal name.
Antonio Sledge.
And are you the same Antonio Sledge, also known as Moontum, who is listed in indictment 22 SC 183572?
Yes, ma'am.
Are you at this time taking or under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 41, 10th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you are charged with the following offenses?
Yes, ma'am.
Conspiracy to violate the Racketeer Influence and Corrupt Organizations Act,
Yes, ma'am.
as well as possession of a firearm by a convicted felon,
Yes,
as
ma'am.
listed in count 30 of this indictment.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges, and that if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your attorney, Mr. Derek Wright, about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Do you waive a formal reading of the indictment?
Yes, ma'am.
Do you waive any and all defects in the indictment, including any with respect to your name?
Yes, ma'am.
Have you been arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Do you, Mr. Wright, know of any outstanding warrants that are related to these charges?
I do not.
Mr. Sledge, has your attorney advised you of the minimum and maximum sentence for each charge that you are pleading guilty to
Yes,
today?
ma'am. Yes, ma'am.
Do you understand that this is a negotiated plea of guilty?
Yes, ma'am.
Which means that the state will recommend to the court the following sentence.
Yes, ma'am.
As to count 1, 15 years to serve on probation subject to the special conditions contained in the plea agreement that I have in my hand that I will show you in just a moment. And on count 30, although you are pleading guilty, sentencing will be withheld until the completion of the initial trial of this case. After the initial trial of this case, provided defendant you have complied with the special conditions outlined in sections B, C, D, F, and I of section 3 special conditions of sentence of this plea agreement, the state agrees that the defendant shall be allowed to withdraw his guilty plea on count 30, and the state shall agree to null pros count 30. Do you understand that the court does not have to accept that recommendation? And we will read into the record the terms of the plea agreement in a moment. Do you understand that?
Yes, ma'am.
Do you understand that the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other if the court does not accept that negotiated plea?
Yes, ma'am.
I'm showing you what has been marked as State's Exhibit 1AS. Do you recognize the document in State's Exhibit 1AS?
Yes, ma'am.
And is that your signature on page 7 of 7 of State's Exhibit 1AS?
Yes, ma'am.
Your Honor, at this time, actually, and Mr. Sledge, have you had an opportunity to review each and every provision within State's Exhibit 1AS?
Yes, ma'am.
As reflected on State's Exhibit 1AS, the current charges that you face are count 1, conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act, and count 30, possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm, OCGA 16-11-133. The negotiated sentence as outlined in State's 1AS is count 1, 15 years on probation, and count 30, sentencing withheld until years on probation, and count 30, sentencing withheld until years on probation, and count 30, sentencing withheld until years on probation, and count 30, sentencing.
We might need to skip forward 2 seconds. Try that.
The agreement is not captured. I'm going to object to skipping forward. I'll see.
Let's see.
Your Honor,
I'm not saying to skip anything substantively. I'm trying to
Right.
see if they can skip over the part where it's just repeating
Skipping,
itself.
yes. We're sharing through a different screen, and we're going to go ahead and pick up
On
at
these
6:40
charges.
At 6:40 where we stopped.
It has complied with the special conditions outlined in section B as in boy, C as in Charlie, D as in Delta, F as in Frank, I as in Indigo of section 3 special conditions of sentence of this plea agreement. The state agrees that defendant shall be allowed to withdraw his guilty plea on count 30, and the state shall agree to null pros count 30. The special conditions of the sentence, as outlined in section 3, are that defendant shall abide in full by each and all of the terms of this negotiated agreement. Defendant's failure to abide by any term of this agreement shall constitute a violation of the agreement. Defendant shall testify truthfully about all matters relating to this case upon which he is questioned at any trial or judicial proceeding stemming from the facts alleged in this indictment. In accordance with testifying truthfully about all matters relating to this case, defendant acknowledges that each and all of the statements contained within the defendant's factual acknowledgments section of this agreement are true. Defendant shall testify truthfully about each statement contained within defendant's factual acknowledgments and any matters related to this case when asked to do so in any proceeding related to the facts alleged in this indictment. Defendant shall possess no guns unless his right to do so is restored. Defendant shall commit no criminal acts. Defendant shall submit to random drug screenings by the Department of Community Supervision and any agency designated by the court in this case. Should the defendant test positive for any Schedule 1, 2, or 3 drug, defendant shall within 30 days of said positive test undergo drug rehabilitation as designated by the court or the Department of Community Supervision and shall successfully complete said rehabilitation program. Defendant relinquishes any Fifth Amendment right related to any statement contained within defendant's factual acknowledgments contained within this plea agreement. Section 4, defendant's factual acknowledgments. Have you initialed each and all of the defendant's factual acknowledgments contained within section 4 of this document?
Yes, ma'am.
And is that initial AS your initial?
Yes, ma'am.
The factual acknowledgments are as follows. Number 3, while associated with YSL and to support and express loyalty to YSL, defendant and co-defendant Demikion Garlington and Quindarius Zachary appeared in a video with another person, AS, where defendant brandished a weapon used in a drive-by shooting, and where on behalf of YSL, defendant threatened to harm a person named Kel, a rival gang member who had begun a relationship with defendant's ex-girlfriend. Number 4, on or about April 28, 2015, as reflected in Fulton County Indictment 15SC 138994, defendant and fellow YSL associates Demikion Garlington and Quindarius Zachary committed a drive-by shooting using the firearm defendant wielded in the video referenced in Part 3 of this section, targeting family members of a rival gang. Number 5, defendant and his fellow YSL associates committed the drive-by shooting referenced in sections 3 and 4 above on behalf of YSL and to increase the notoriety, reputation, and fear of YSL. Number 6, defendant admitted committing and was convicted of aggravated assault and participation in criminal street gang activity, among other charges, for his participation in the drive-by shooting referenced in sections 3, 4, and 5 above. Number 7, defendant was told by another YSL associate that immediately after the murder of Donovan Thomas Jr., YSL associates met at the McDonald's on Cleveland Avenue in Atlanta, Georgia, to discuss the murder. Number 8, defendant personally knows that one or more YSL associates committed the murder of Donovan Thomas Jr. on behalf of YSL. Number 9, on January the 10th, 2015, after the murder of Donovan Thomas Jr., defendant and other YSL associates gathered at the home of Jeffrey Williams, aka Young Thug, who gave defendant and other YSL associates cash money to lay low. Number 16, defendant has personal knowledge that he and other members or associates of YSL have either participated in or directly committed at least one of the following crimes in order to increase the notoriety and reputation of YSL: murder, armed robbery, aggravated assault, attempted murder, theft, illegal gun possession, and illegal drug possession and sales. Mr. Sledge, have you had an opportunity to go over each one of the defendant's factual acknowledgments and make corrections where necessary?
Yes.
And do you now acknowledge under oath that each of the factual acknowledgments that you have initialed in this section are true and correct and accurate to the best of your ability?
Yes, ma'am.
Part 5 of this plea agreement, Your Honor, states that defendant's sentencing acknowledgments are as follows. Defendant understands fully that if he violates any provision or any special condition of this plea agreement, the district attorney can and will use the contents of this document and agreement during any judicial proceeding. Defendant understands fully that if he violates any provision or any special condition of this plea agreement, his probation for this sentence may be revoked in its entirety, and the district attorney will recommend that defendant serve any remaining portion of this sentence in confinement at the Georgia Department of Corrections or prison. Number 3, defendant understands fully that any violation of any provision or of any special condition of this plea agreement shall result in defendant being sentenced on count 30 of this indictment, and the district attorney will recommend that the defendant serve the maximum sentence allowed by law. Number 4, defendant understands fully that if prior to the conclusion of the initial trial of this case, defendant fails or refuses to testify to any fact that he acknowledges in this plea agreement, such failure or refusal nullifies any promise made by the district attorney to null pros count 30 of this indictment. Number 5, defendant understands fully that defendant's violation of any provision or of any special condition of this plea agreement prior to the conclusion of the initial trial of this case shall nullify any promise made by the district attorney to null pros count 30 of this indictment and may result in defendant being, and Your Honor, there is a typo that is in this document. It's the word should be being, and it's spelled B-E-G-I-N. I'm going to ask that defendant just strike through and initial that word, B-E-G-I-N to B-E-I-N-G.
Through. Change it to E. Then initial right there.
And Mr. Sledge, is that your initial above the strike through of the word begin to change it to being?
Yes, ma'am.
Okay. And may result in defendant being sentenced to serve as much as 35 years of confinement in the Georgia Department of Corrections or prison. Number 6, defendant understands fully that no promises, agreements, or conditions have been made other than those set forth in this document. Mr. Sledge, are these your initials on each section under defendant's sentencing acknowledgments?
Yes, ma'am.
Mr. Sledge, do you agree that the following statement is one that you have read, fully understood, and signed your name acknowledging? I, Antonio Sledge, have read and carefully reviewed this agreement. I have reviewed and corrected where necessary for accuracy each statement contained in defendant's factual acknowledgments, and I acknowledge the truth and accuracy of each and every statement listed therein. I fully understand this agreement, and I've had an opportunity to discuss this agreement and each of its provisions with my attorney, Mr. Derek Wright. No promises other than those contained in this document have been made to me in furtherance of this agreement. I freely, knowingly, and voluntarily enter into this agreement without force, threat, or coercion. Is that the statement that you acknowledged in this agreement?
Yeah, ma'am.
And is that the statement to which you signed your name underneath?
Yes, ma'am.
Your Honor, the state tenders as evidence State's Exhibit 1AS.
No. Any objection? States 1AS is admitted for purposes of plea.
Mr. Sledge, I'm showing you, and Your Honor, I'll show defense before I present it to him, what was admitted during that session as 1AS. If anyone wants to see it, if not, I'll go ahead and approach the witness. All right. Mr. Sledge, would you please take a look at 1AS and tell me if 1AS, which was admitted for the purposes of your plea, and the document we have been referring to, yes, thank you, as states 444 Yankee, and I will now add back the first two sheets. Would you please look at those two documents and tell me if states 444 Yankee is an exact copy of State's Exhibit 1AS that you signed on December 28th, 2022.
Look at the whole thing or just the...
Yes, sir. Please look at the entire thing.
Yes, I remember this one.
And is State's Exhibit 444 Yankee an exact duplicate of the document labeled State's Exhibit 1AS?
Yes.
All right. Thank you, Your Honor. One moment.
All right, is there a cross-examination of Mr. Sledge? All right, go ahead, Mr. Sharp. Yes.
Mr. Kokomo's in need of the Zoom link?
It's the same it's been all week. Can you look at maybe a prior day's email? Or the state will forward it. Thank you. He's got it. He's in.
Mr. Sledge, good morning.
Good morning.
My name is Max Shard. I represent Shannon Stillwell, okay?
Yes.
All right. I'm going to be asking you some questions about that document that you were just reviewing. Do you have that up there with you?
No, she took it.
Okay. If I ask you specific questions about that document, do you think it might be helpful for you to have it in front of you to refresh your recollection?
Yes.
Okay. Your Honor, may I approach?
Yeah, I think it's right up with the court reporter.
Okay.
Oh, okay.
I'm not.
Okay.
We'll get there.
Okay.
And just please listen to my questions and then answer truthfully, okay?
Yes.
All right. Mr. Sledge, I'm going to ask you to go back to December 28th of 2022, okay?
Yes.
Now, that is the day that you pled guilty, correct?
Yes.
And that's also the day, as I understand it, that you initialed that document. Is that correct?
Yes.
Initialed the factual acknowledgments within the document, correct?
Yes.
All right. Let me ask you one question before I get there, though. What day were you arrested on this case?
I want to say May 27th, 2022.
May 27th, 2022. Well, that works out well for my limited math here. Okay. So, May 27th of 2022 to December 28th of 2022. That seems to me 7 months. Is that correct?
Yes, 7 or 8.
Okay. So on December 28th of 2022, when you initialed those documents, you had been locked up for 7 months.
Yes.
Okay. You had previously moved for a bond in this case, correct?
Yes.
You moved for a bond on October 13th, I believe, 2022?
I don't remember the date, but yes, I know.
It was in October?
Yes.
And the state opposed your release on bond, correct?
Yes.
And Judge Glanville denied bond, correct?
Yes.
Okay. So on December 28th, 2022, you had been locked up for 7 months and 1 day, and you did not have a bond.
Objection, answer, and compound.
Sustained.
On December 28th, 2022, you did not have a bond, correct?
Sustained.
All right. Let me ask you, when you were locked up, we're saying locked up, where were you living? Where were you held?
At the Fulton County Rice Street.
Okay. That's Fulton County Jail?
Yeah, jail.
Okay. And we're not, generally speaking, is that a nice place to be?
Objection, roll.
Overruled.
No.
Is that a dangerous place?
Yes.
Is that a filthy place?
Yes.
Okay. On December 28th, 2022, there were some things going on in your life, correct?
Yes.
Okay. You've already shared with us that your mother was ill.
Yes.
Certainly, on that day, you wanted to get home to your ill mother. Isn't that correct?
Yes.
You are also a father, right, Mr. Sledge?
Yes.
You have 8 children, is that correct?
Yes.
Okay. On December 28th, 2022, I don't need to know the age of every child, but what was the age ranges?
23, the youngest 9.
The youngest was 9.
He 9 now.
Okay, so about 7.
Yeah, about 7 then.
All right. And do your children live in Atlanta?
Yes, all of them.
Okay. Do you spend time with your children?
Yes.
Sustained.
Do you attend to your children's daily needs?
Sustained.
Your Honor, may I be heard?
You may.
It goes to his need to get out of jail.
All right, we'll get to it.
Okay. Do you attend to your children's daily needs?
Yes.
Do you drive your children to school?
Let's move along a little bit.
Okay. Did you have a significant other at the time?
Yes.
I have a rule.
Yes.
And I don't even need to say her name. Her initials are DB?
Yes.
Okay. On December 28th, 2022, did you miss DB?
Yes.
Did you miss your children?
Yes.
You indicated that Derek Wright is your attorney.
Yes.
And he's represented you in the past.
Yes.
And you hired him on this case.
Yes.
Okay. When you testified, I want to make sure I'm correct on this, you paid him a certain amount of money, and I don't need to know the amount.
Objection, relevance.
He's testified that he did not, his understanding was he did not pay his attorney. You didn't, the money that you paid your attorney, you knew it wasn't enough for him to go to trial on this long case, correct?
Yes.
That was your understanding.
Yes.
That was his understanding.
Yes.
You did not have an attorney to take this case to trial.
All right, no. Now that we all know that that's not true, that anybody who can't afford an attorney is entitled to get an
Well, I'm
attorney
gonna get
without
there.
cost to them.
I'm going to get there. There were people in this case that couldn't afford an attorney, correct?
Objection, Your Honor, speculation, relevance.
People weren't. People still don't have
Hang on,
attorneys.
hang on. Don't talk over each other. That is not relevant to the question that you're asking him, nor to this trial going on right now.
Your Honor, may I be heard?
Yes.
If he knows he's going to sit.
You may, yes. You know what? Let's break for lunch, because I know that this is going to take more than 30 minutes for you to do your cross. So let's just break for lunch right now. Huh? Time? Oh, right. Well, I've got some, we have to deal with some other matters. Let's say 1:30. Is let's take up this objection.
So, Your Honor, and I say this not in a pointed fashion. You weren't here in the beginning of this case.
Yeah.
And I know that you're not presiding on the case with the other individuals. The reality is, people were severed off this case because our public defender system did not provide people attorneys. People were sitting in jail for up to 2 years. I'm not even sure everyone has an attorney to this date. These gentlemen that are not sitting here, that are sitting in 901 Rice Street, 2 years later, I don't even know if they have attorneys now, but I do know when we started this trial, people were severed because the public defender's system had not provided attorneys. Mr. Sledge knew that. Mr. Sledge, and this is the reality, and I don't think we should hide it from the jurors. The reality is Mr. Sledge had two options: plead guilty or wait for an appointed attorney to try this case, and he would have been sitting in jail, and he'd still be in jail today.
All right, all of those cases are ready to be tried right now. Everybody who's been severed out other than for that reason is ready. And,
okay, well, right,
mean,
and they're still in jail. And
well, so are all of these defendants.
Well,
but we're not going to get into that, are we?
Well, at this point, I really probably wouldn't mind, but I'm not going to speak for everyone else. But it goes to his mind state. He had two options: either take this plea or end up in the same bucket that Demekion Garlington and Demise McMullen and other people were in, which was be unrepresented, sit in Rice Street until the state gets about. So when we say we know people are appointed attorneys, yes, I know theoretically under the Supreme Court precedents and under our Constitution, appointed indigent individuals are supposed to be appointed attorneys, but in reality, that did not happen here.
That may not have happened immediately, but
It
just
didn't
happened.
happen.
And
It didn't happen until very recently.
I mean, that does not need to be what is there are so many collateral issues in this case. So if you want to ask him much more pointedly what his understanding was, but we don't need to go through every co-defendant who may or may not have had it.
Oh, I wasn't going to do that.
To be going down
No,
that
I was
road.
just asking if he knew. I was saying he was aware that attorneys were not being appointed to represent the other people he was with, and he didn't want to be in that situation. And Miss Love was objecting, and I never got a chance to get to it.
I mean, for all I know, Ms. Love's now going to want to cross-examine him on his actual financial affairs, which I think would be fair, because I'm not sure, that wouldn't be fodder for redirect at this point.
I mean, I don't really have a problem with her cross-examining him with his financial affairs. Mr. Wright might.
Well, I mean, why don't you propose a couple of questions that you think will get to the heart of the matter?
Well, I've already established that he didn't hire Mr. Wright to try the case. He was aware that other people that had been arrested that could not afford attorneys were remained unrepresented 7 months later. And he didn't want to be in a situation where he was sitting in 901 Rice Street without an attorney to represent him.
You are not going to be able to ask him about well, I see what you mean. Okay, well, let's not give it the impression that it's indefinite and still going on right now, because we all know that's not accurate.
Well,
that's not accurate. I can pull up all 19 of the co-defendants, I guess, and look and see, but they're all represented. They have been for quite a while, right?
Yes, gone to several hearings with them and their attorneys.
They're at like final plea stage, aren't they?
Yes, they're actually pushing for trial.
Except that, yes, which needs to happen, but that's a whole other issue. Okay, so you get about one more question on that, and then move on.
Two.
Okay, well, what are the two?
That he was aware that on December 28, 2022, there were people on this case that could not afford attorneys. They had not been appointed attorneys by that date, and he didn't want to be in their situation. I guess that's three, if we're not going to make compound.
May I respond?
You may.
Judge, I would object to Mr. Sharp's assertion, number one, that he's established that Mr. Sledge did not have the ability to secure Mr. Wright for trial.
So he said on direct that he didn't. He said, I couldn't afford Mr. Wright for trial, and that's why I pled.
Okay, we'll get into that. Also, I object to the speculation regarding, his question regarding whether or not anyone else could afford or had an attorney or would be appointed an attorney or might have to wait for an attorney.
Wasn't asking for speculation. We were people there that did not have attorneys. They all sat right there and looked sad, and we all openly
Yes, Ms.
discussed
Love.
it.
Thank you.
That is
It is
true,
an
right? That on December 20th of 2022, there were at least some co-defendants without an attorney yet because there are so many conflicts.
Mr. Sharp's line of question established that Rice Street is
There's some.
We're gonna do this other matter first.
Okay.
I don't think
You're not ready to
Judge says
start?
it's fine.
Okay.
No, it's okay.
I just wanted to let you know.
From an NTSC. Are you here?
What frame rate?
Henry, you, okay. And I'll let them know that we're gonna take a break. Because I don't think the DA is ready anyway. They're all the victims.
Yeah, they're not all here yet, so, yeah. You ready there?
Yeah, we're good. Okay, we're ready on the line. So we'll need a break. I can give you more break. Okay.
Please remain seated. Come to order. This court is now in session.
Appearances on the Melendez matter?
Good morning, Your Honor. Deputy District Attorney Dan Owens for the people.
Morning, Honor. Jim McMahon, alternate public defender's office on behalf of Crystal Melendez, is present for the court custody.
And Your Honor, this is a joint request for one, or we hope is one last continuance. We have cleared the date of October 16th at 9 a.m. 18th, pardon me. The Friday, yep. The 18th at 9 a.m. Based upon the same issues that we've outlined for the court previously.
All right.
Judge, can I have it? Oh, what is this? Oh, Judge, will you sign those? Those are the orders for the bond.
Well, this one?
Oh, can you put all in there? No, yeah, you're good.
This one?
Oh, that kind of back.
I guess I can fit it.
I'll give it home.
Excuse me. Media people, whose microphone is this?
That's right.
Okay, this can't be a council table.
Okay. I asked Bill if he said it was okay.
It's not okay. Thank you.
I didn't say make the council table, but I said the judge's office. Sorry.
Thank you.
Thank you. Are you part of the media? Yeah. Sam? I'm supposed to push record. We're kind of used to that as a family, but take it
Camera one could be focused one person.
Okay, so we're not ready yet.
Thank you.
Hi.
Right, thank you.
Yeah, okay.
Probably be right in the Euro.
Yeah, that's right. That's
I'm gonna move one there.
let's turn that. The victims. change it. Alright, hold on. This one.
Late afternoon, early afternoon.
Yeah, and early. I know.
She was like, yeah.
going to put a microphone here. Just make sure you speak loud and slowly so the court reporter hears your entire statement, okay? It won't be yet. It'll be a little while.
Oh, the coach is the coach.
Yeah.
The surf line.
And everything was not
Judge
Please remain seated. Come to order. This court is now in session.
All right, the record will reflect on the Boulevard matter. I've got both counsel, Mr. Boulevard. Before we begin, there's a few things that we need kind of in order, so I want to make sure that we can do that. Mr. Boulevard, you have the right to appeal the judgment of this court. That must be filed within 60 days in this court and not the Court of Appeal. Do you understand that?
Yes.
Thank you. All right. A couple things before we begin. We have a new trial motion which we will do first. So I will start with the defense. You're up.
Thank you. Good morning, Your Honor. Jody Green, Deputy Public Defender on behalf of Mr. Boulevard. Your Honor, we did file a motion for a new trial pending what was the verdict in this case. This was something that we had addressed with the court and counsel during trial as it happened right after, right during, I should say, Mr. Boulevard's testimony. The court at that time asked us to return the following day with a transcript from Mr. Brian Edwards' phone calls to his family members, which was the subject of the questionable conduct by the prosecutor that we believe rises to the level of prosecutorial misconduct. When we returned the next day, we provided a transcript to the court. The court had an opportunity to review it. At that time, the court offered a remedy which the defense did not believe was proper and fully addressed the issue. The remedy offered by the court was to instruct the jury that they could disregard or that they should disregard that line of questioning as well as the answer provided by Mr. Boulevard. The defense elected instead of that remedy that we felt was not proper and didn't fully address the issue to argue it to the jury. After closing argument, the court instructed counsel that it had reviewed the transcripts again, agreed now with defense that that question should not have been asked by Madam Prosecutor, but since it was post-closing, the court reiterated its earlier argument that it didn't think that it rose to any sort of level of error in the sense that Mr. Boulevard had been on the stand for 3 days and it came towards the end of his testimony, and that ultimately it wouldn't impact given the length of the testimony. The defense disagrees. We filed this motion asking the court to reconsider and to allow a new trial in the matter, given all the arguments laid out specifically in our papers. We would just like to point out that in a case, in any criminal case, an elevated standard of conduct applies to the prosecution. They have a duty not to just get that Mr. Edwards did not ever have a conversation with Mr. Boulevard about this case. They were separate. Mr. Boulevard was in the hole, or Mr. Edwards was in the hole. There was no communication, and there is nothing in these phone calls to substantiate that there was ever a conversation between the two. If the prosecution really believed that that was the case, they would have brought Brian Edwards in, they would have had those transcripts, they would have done things to be able to fully substantiate, and that's where the issue lies, is that they asked questions that they could not substantiate. A sort of idea that this was done accidentally or with misremembering what the transcript says, it really is not the question. This does not have to involve any sort of ill intent or ill will on behalf of the prosecutor because they are held to a different, higher standard than other lawyers in court. And so we are asking the court for all of those reasons to order a new trial. Although the court did offer a remedy, we do not believe it was a proper remedy that would fully remedy the situation in front of the jury. The damage had been done, that bell could not be unrung. The only way to properly fix that was to instruct the jury that the prosecutor had committed prosecutorial misconduct and that that was something that they could consider in the totality of the case as they evaluated it and deliberated. Thank you.
All right, Madam Prosecutor.
Thank you, Your Honor. There was no misconduct or error in this case, and the defense has not cited any legal authority showing that the two questions that I asked the defendant on cross-examination require a new trial in this case. And the two questions I asked were based on discovery jail calls that had been out since March of 2023, The defense was fully aware of these calls, as was the defendant. There were multiple statements made by Brian Edwards on these jail calls to his sister and to his wife, indicating that Mr. Edwards had a lot of information about the defendant that could only have come from the defendant. Mr. Edwards knew generally what the defendant looked like. He knew that he was involved with TikTok. He knew the defendant's defense in this case as a heat of passion defense. That is not common knowledge. That was not knowledge that was brought forward at an arraignment or the preliminary hearing or anywhere in court. That was the defendant's defense that we heard during this trial. The defendant had talked in similar jail calls to his parents about his heat of passion defense, about raising that defense so that would allow him to get out earlier. He told Mr. Edwards and our inmates at jail about this defense, which is how Mr. Edwards knew about it and why he was relaying that the defendant had to prove that he killed his bitch and the other woman or the other man in the heat of the rage, and that's what would get him only 5 years per victim. Mr. Edwards had a lot of very specific information about the defendant's, not only his defense of heat of passion, but also details about the killings. It was very apparent to me in reading the transcripts and listening to those calls that the defendant provided this information. There was one particular quote from Mr. Edwards. First of all, Mr. Edwards was arguing to his wife that, his wife and the other man were inside his house, meaning the defendant's house, as if that was some kind of excuse or justification for killing. Mr. Edwards relayed to his wife that the defendant's wife and the other man were doing drugs inside the apartment. That is not public knowledge. That is not even the truth. That is information that, besides SDPD knowing about a potential bag of cocaine, presumably at the scene, the only other person that had information about drugs at the crime scene was the defendant. Not Mr. Edwards, not anything Mr. Edwards heard on TV or read in the newspaper. That was nowhere in any of the media. So the information that Mr. Edwards had about any potential drugs at the scene came from the defendant. The defendant is the only person that had that information. So to say that Mr. Edwards and the defendant never had a conversation, that is not apparent to me. That is still not apparent in those calls. Mr. Edwards never said in either of those jail calls that he had never met the defendant during his whole time in jail. Mr. Edwards never said, I have never spoken to the TikTok killer or the defendant at any point in time in jail. All he said during those calls was that the defendant was in the hole that month. So maybe he didn't have a conversation with the defendant that month. But there is nothing in those calls that indicates that the defendant had never had a conversation with Mr. Edwards. So based on all the information contained in the calls, I certainly had a firm belief that the defendant provided that information. And when the defendant is testifying in a first-degree murder case and has a heat of passion offense and is testifying that he felt either badly about what he did, that he was sorry, or that he didn't mean to do it, he testified that he didn't even realize he shot Anna. When the defendant is making all those statements during his testimony, it is certainly relevant for the prosecutor to ask him questions on cross-examination that go towards his lack of remorse. And the fact that he was bragging to inmates, making statements to inmates about killing Anna and Ray or killing his bitch and the man she was cheating with, the kinds of statements that I heard in those jail calls, it is certainly very relevant for me to ask those questions on cross-examination. Because that shows the defendant did not have remorse for what he did. It wasn't in the heat of the moment. It was planned, and then he's bragging to inmates about it. I limited my inquiry to 2 questions, and then I moved on. I didn't argue it further. I didn't even argue it in closing. Mr. Edwards was in jail for a murder case as well. I'm not going to bring in another suspected murderer to testify in a case where there's overwhelming evidence of the defendant's guilt. The prosecution can elect what witnesses it will call or not, and that's what I did in this case. The defendant, his response was certainly showing consciousness of guilt. When I asked him, did you ever brag to Mr. Edwards, his response should have just been no. If he really never had a conversation with Brian Edwards or any inmate in jail about the killings, his response would have just been no. That was not his response. He had an outburst. He told me, is this some kind of jail informant that you're asking me about? That shows his guilt in the fact that he knows he made these statements to inmates in jail. And so it's perfectly reasonable for me to ask those questions.
Bullshit.
Yeah, you're bullshit.
All right, let me make something clear right now.
I'm sorry, son.
If there's any disturbance, you will be put outside, all right? That happens only once, it's happened now, it will not happen again. And that includes you, Mr. Baldwin, I don't want, thank you. Go ahead.
Thank you. The defense cited numerous cases in their brief without the facts, and those facts are not the same scenario here. The defendant cited just very briefly the case of People versus Centeno, a case where the prosecutor argued to the jury a misleading standard of proof in the case. That did not happen here. I never argued an improper standard of proof. The defense cited People versus Force, a case where the prosecutor made a comment to the defense attorney that, oh, I may charge your client with perjury if he testifies inconsistently. So the defendant in that case did not testify during that trial. That did not happen here. I didn't raise any perjury charges. The defendant was able to testify fully for 3 days, showing his side of the story. So the factual scenarios in those cases cited by the defense in their moving papers are completely different than the factual situation here. The other cases cited were People versus Fasaro and People versus Jasso. Those cases were not overturned. New trials were not granted in those cases. The court may have found misconduct for arguments by the prosecutor. However, it was harmless error and those cases were not overturned. The People in my moving papers, I cited People versus Watkins. That is a case with a very similar factual scenario to this one. In that case, the prosecutor asked the defendant on cross-examination a question about him laughing and carrying on outside the presence of the jury. That question was objected to, it was sustained. However, the court ruled in that case there was no misconduct based on the prosecutor having a good faith belief in asking a question that explores the remorse of a defendant for a killing. That is similar to what happened here. I was asking questions to explore the defendant's remorse and the fact that this was not a heat of passion case, that it was a planned killing. So there was no misconduct in this case. I know the defense brought up that the court also committed error. That was not the case here. If the court doesn't believe that there is misconduct, which there was not here, then the court is not required to instruct the jury that there was misconduct. So the court did not commit error in that sense. The court did offer a remedy to the defense, which was striking the questions and the answers, and the defense chose strategically not to do that because the defense wanted to be able to ask Mr. Boulevard further questions on redirect and to be able to argue things in closing, which is what she did. And so the defense can now not come in here and say that there was not a proper remedy by the court when she chose not to take that. The court also has to find that there would be prejudice to the defendant or that there would be a more favorable outcome if those questions had not been asked. And neither of those exist here. There was no prejudice in asking the defendant 2 questions that he was able to explain on his own, and the jury is left to either believe him or not believe him. That is true of all of the questions asked of him and his testimony in general. There would not have been a more favorable outcome here. This is a case where there was overwhelming evidence of the defendant's guilt, and that was shown through his testimony, through the crime scene, through his admissions, through video evidence, through audio evidence, through evidence in his vehicle, social media. There was an abundant amount of evidence proving the defendant's guilt. And so 1 or 2 questions asked of him on cross-examination that does not prejudice him. He certainly received a fair trial in this case. He was able to fully testify and tell his side of the story, and there would not have been a more favorable outcome. What I also attached to my opposition was a declaration from District Attorney Investigator Elliot Schaefer. That's S-H-A-F-F-E-R. And in that declaration, Mr. Schaefer reiterated the comments made by the jury foreperson after the verdicts. And the jury foreperson indicated that the jury looked at all of the evidence in this case, and they based their verdicts on the defendant's actions and all of the evidence, not on his words on the stand. And so it was certainly evident to the jury that there was not a single question and answer that would have swayed them into changing their verdicts. And so I would argue that there was no misconduct either by the prosecutor or by the court, and that the court should deny the motion for a new trial and proceed with sentencing. Thank you.
May I just briefly respond?
Sure.
Thank you. Just to the last point the prosecution made about Mr. Schaefer having overheard something that the jury foreperson said. I wasn't present, but I do know that Fox 5 News was present, and there was a quote, not just something that they overheard, but a direct quote by the jury foreperson, and it was more complete than what Mr. Schaefer reported in his declaration, which was that immediately after the verdict, the foreperson explained that they made their decision based on Mr. Boulevard's actions on the stand when he was testifying, not his words. And so I think what Ms. Frost is missing the point of here is that Mr. Boulevard was put in a position where he had to deny accusations that simply were not true. And when Ms. Frost is standing up with very thorough notes for her cross-examination, and I can't express enough to the court sort of the optics of it, as Ms. Frost has a giant binder that she's checking off question by question by question. And what's left in the juror's mind is an impression that she somehow has information that would exactly corroborate everything that she's asking of Mr. Boulevard, but yet here he is up on the stand denying and lying to them, which is exactly what the jury is asked to do when a defendant testifies. We all know that that jury was absolutely salivating, waiting for Mr. Boulevard to take the stand, to hear what he had to say. And it wasn't a matter of, as we know, what he said, but how he said it. Ms. Frost put Mr. Boulevard in a position where he was forced to deny something that frankly is just not true. And they had no evidence to corroborate it. They had no evidence to bring in to show the jury that what they were in fact asking was true. I don't know if Ms. Frost is unfamiliar with the way a jail works, but they have televisions, they have access to news, they talk to each other. And this case, as we can see in this courtroom right now, was all over the news in October when it happened. The news was constantly speculating about who was involved and what the facts were, and what sort of defense this individual may have. Heat of passion is a very common, well-known defense when someone is charged with the murder of their spouse. So just because Mr. Edwards had some sort of knowledge that this might be a heat of passion case and it involves Mr. Boulevard, a TikTok star, when the media is constantly plastering this all over local news that jail inmates have access to, there is still no credible proof that exists in the transcript of these calls that Mr. Brian Edwards had a conversation with Mr. Boulevard. And if the prosecution thought that was true, when they got these jail calls, they most certainly could have sent an investigator to ask Mr. Edwards about that. But they didn't. And they didn't for good reason, because it simply is not true. And what we have here is a situation where Mr. Boulevard was prejudiced. And we can see that from the jury foreperson's quote to Fox 5 News, that it was not a decision based on his words, but his actions on the stand. Ms. Frost was trying to get a rise out of him. She succeeded by asking him an unsubstantiated question that she simply could not prove. The court offered a remedy that was insufficient to fully address the prejudice and harm already caused to Mr. Boulevard, and based on that, we're asking the court to grant our motion for a new trial.
All right. A few things. Let's kind of understand what we're talking about here. First of all, I have reread the transcripts. The transcripts speak for themselves. To a certain extent, I will adopt my earlier comments on this, quite frankly, when there was a motion for a mistrial. There's a few things that we need to talk about here. The first thing is, was there misconduct? That is judged by an objective standard, and here we have a situation where obviously the prosecutor asked a question that, in her mind, which I will accept, she believes was in good faith. It really wasn't answered. Everything kind of stopped at that point. But the question is this in and of itself misconduct? And as I've said earlier, the question should not have been asked, but we have to analyze, was this objectively misconduct? And again, I would, based on looking at other cases involving prosecutorial misconduct, no, it doesn't amount to that standard. Again, it was not a very smart thing to say, but again, you ask that, is it misconduct? No. But moving on, this is more important. Did the defendant suffer prejudice? And the answer to that is absolutely not, even if there was misconduct. So we're even assuming that there is prosecutorial misconduct. The question was whether or not these two questions contributed to the verdict. And the answer to that is no, not at all. And I think what you have to do is look at the totality of the circumstances. And if you do that, you'll see that the questions themselves, by themselves, not just it didn't have impact on the verdict, were fairly insignificant, Also, we tell the jurors over and over again that the attorney's questions are not evidence. There's a question. It's not evidence. And we, of course, presume that the jurors follow the law. The court did offer various remedies. The defense made certain tactical calls. And here we are today. But the bottom line here is I don't know what the jury foreperson said about the defendant's actions on the stand. But there's no question that if you look again at the totality of the evidence, of which we will outline in a few, that's what the jury is looking at. Yes, I would agree with counsel, and I had a quote here that his state of mind and intent were at issue. Of course they were. There's no question about that. But when we look at the defendant's state of mind, we're just not looking about what he says on the stand. We're looking at all of the circumstantial evidence that shows his state of mind. And that's what the jury did. And the jury came up with their verdict. They basically had the choice of whether or not this was a willful, deliberate, and premeditated, for lack of a better word, a cold-blooded murder, or whether or not this was heat of passion, which is basically a lapse in judgment under extreme circumstances. The defendant was on the stand for 3 days. I've been doing this a long time. This is probably my 37th year. I have never seen anybody on the stand for 3 days. So the jury had an extraordinary amount of time to evaluate the defendant's credibility. And the idea that it would come down to, again, two insignificant questions is just not, it's not reasonable. So based on the two prongs of was this misconduct? No. And again, was there prejudice? No. Moving on to whether or not this court made an error in refusing to either grant the mistrial or finding some other remedy, for lack of a better word. I had suggested at the time that we simply strike it because, again, the jurors are presumed to follow the law, and it's been my experience they do. I gave the defense the options to this because I think that's only fair, and for certain tactical reasons they elected their remedy. Obviously they don't like the verdict the way it came back, but elections have to be made. So based on all of this, then, the defense motion for a mistrial is denied. All right, so now we will go on to Madam Prosecutor, I have the prosecution go first because I always give the defendant the last word.
Thank you, Your Honor. First, I would like to start with the victim impact statements. There are several members of the family present here in court today, and some family also on Microsoft Teams who would like to make impact statements. I would just let the court know I did submit numerous victim impact statements from both friends and family, both Anna and Ray. I know the court has had an opportunity to read those. Many of those members are here in court today. Not everyone will give their impact statement again, but there are some family members that would like to, and I will just go in order.
Can you just make sure to say your first and last name and spell both for the record?
That's my phone. So I can't see sometimes.
Ma'am, please state your first and last name and spell both of those names for the record.
Yeah, Hermes Sarton. Your Honor. Or,
I'm sorry.
What my mom did to you? What mom did to you? My mom did you what? Sorry, Your Honor. What did they do to you? You didn't do anything to you. You know Anna Marie is not gonna go cheat
right.
if you didn't cheat first.
All right. Ma'am, if you're not going to be able to control yourself,
Sorry, Your Honor.
I'm going to have to
This-
excuse you. Mr. Abulman,
This feeling is like
please.
make me sick. Your Honor, my name is Hermes Sarton. And I want to share the court the devastating impact that loss of my sister Anna Marie has had on our lives. My sister was a gentle, loving, sweet, young woman whose absence has left a hole in my heart that can never be filled. This man has taken her life and also shattered the hearts and lives of so many loved Anna Marie. Anna Marie was not only my sister, but also one of my best friends. Our childhood was filled with laughter, love, and countless moments of joy. My favorite memories with my sister were of us growing up together. Her beautiful smile and laughter always made us happy. As we grew up, I can remember so many fun times when our family would get together because her presence was, I can remember so fun times when our family would get together because our presence was always so uplifting. She always thought of others first before she would take care of herself. She was always very uplifting to those around her. She had such a gentle spirit, kind, and could easily find joy in the simplest of things. She brought joy and happiness to all those around her. And until now, I still have a hard time knowing my sister is gone. No more calls, birthdays, Christmas, and Mother's Day texts and calls for her. Looking at my sister pictures and video with her is now just a distant memory. I will dare take peace of her heart, but also beautiful soul, inside and out. My sister was the most loving, patient, gentle, and forgiving person, and this person took her away from us. He was the one who was supposed to protect his wife and a child, but instead, he made them scared and even terrified of him. Throughout the trial, He pretended to be surprised that Anna Marie wanted to leave him. As you can see, my sister tried so hard to forgive him and had him so many chances and covered all his abuse and lies. She did not even tell me about the abuse just to protect him. But he took advantage of her and kept abusing her anyways. But he lived at our families when he lived at the family house and also on the phone. He talked like an angel and promised he would never hurt my sister. And Ali, if I had known what my sister had been through with all that abuse, if I had known, if I had known, I would have flown again to see her and do my best to take her and Amira away from you. You didn't take away my sister's life, but also my niece's future because of your selfishness. The damage you have caused impossible to measure. And my parents trusted you when you brought Anna Marie and Amira from the Philippines to the States. You promised my mom that you would take good care of them, as my parents did for Anna Marie and Amira back in the Philippines. But I had no idea that my sister's life would be miserable living with you. Treated my sister like she didn't matter, but she mattered. We love and miss her so much. My sister wanted the best for you and Anna Marie, but you messed up, Ali. And you messed up. The person who said good things about you was my sister. I can imagine how this evil act has changed all of our lives, especially Amira's life. Amira lost the two people that were supposed to love and care for her, especially her favorite person and loving mother. You took that away from Amira. But of the people you killed had a beautiful life ahead. Many people love and care for both of them. You ruined so many people's lives because of your selfish action. You were the one who messed up, and now you are trying to make people believe you're a victim in this case. I knew when I first met you in the Philippines that you were not a good fit for my sister. After you disrespected my mother in front of me, and I should have followed my instinct. Only you know how many years my sister suffered from your hands. But she still tried to stay and love you, hoping that you will change. I told you before that if you didn't want her, you could have brought my sister back to us. You could have brought my sister back and Amira back to us. But you made a choice. You made a choice. I am not realizing why she was afraid to visit us, even though we're just like a few hours away. It is because you were controlling her and Amira, so they couldn't tell how evil you were. Anna Marie and Amira were planning to visit us in December 2021 for family gathering, but you didn't give my sister that chance. Nobody deserved to be treated like you treated my sister. You ruined her life, you mocked her, you disrespected her, you abused her, you controlled her, and then you killed her. You killed the only person who cared for you and loved you. In your honor, the loss of Anna Marie is an unimaginable tragedy for our family. Her death has left us all heartbroken, and family gathering feel empty without her laughter and her presence. Her daughter Amira had lost a loving and nurturing mother, and we lost a sister, a daughter, and a friend. The pain of her absence is the constant reminder of emptiness that can never be filled. We wake up every day wishing that this nightmare was just a bad dream. But the reality that we are forced now to live without her. The trauma of losing my sister in such a horrific is something we will carry with us forever. No sentence can ever bring my sister back to us. But we hope that justice will be served and that the person responsible for the highest crime will be held accountable. We hope that through this statement, you can understand the depth of our loss and lasting impact it has had on our lives. For me, the death penalty is what this man deserved. He has no more place on this earth, but I would agree with what my parents say, a life sentence without parole. Thank you for allowing our family to have a voice and for considering the profound impact this loss has had on our family. Thank you, Edward.
Thank you.
Oh, I can read it.
And now she's going to read a statement from Anna's mother, Amalia Miller, A-M-A-L-I-A.
Your Honor, hello, I am Amalia Miller, the mother of Anna Maria Bulaban, the wife of Ali Bulaban. I cannot fully comprehend why Ali would kill my daughter. The pain Where am I? The pain is unbearable, and I cannot accept what happened to her. As her mother, I knew my daughter well. She was a kind and loving child who never caused me any trouble. She was a caring parent, a thoughtful sister, and always cheerful and playful. Her loss is incredibly painful. Painful for me as a mother. The impact of what happened has left me devastated. I cannot sleep when I think about her. My only prayer now is for justice to be served for my daughter and for the person responsible to be punished. We ask for justice and for life sentence without parole for Ali Bulaban. Only then will I and my family find some peace of mind. It is also painful for me to know that my granddaughter will grow up without her mother. Every time I remember, I cannot help but cry. And I have lost my appetite. My prayers are my only source of strength, and I pray for the end of this mourning for my daughter. I love her dearly, and the pain is overwhelming. I pray for the strength to cope with this agony. I rely on the Lord to help me end this pain and longing, as does my family. I am grateful for the answered prayers, and I hope my plea for Ali Abulaban punishment, life imprisonment without the possibility of release, will be heard. I trust that you will listen to my request. Sincerely, Amalia Miller. Thanks.
Okay, next it will be Maria Cardenas. She would like me to read her statement. My son Ray was a good man, hardworking, noble, without malice. A good son, brother, grandson, uncle, nephew, and friend. Full of light, with a whole life ahead of him that had so much to live still. I, as a mother, ask of you to be just and give Ali Bulaban a sentence of life in prison for taking the life of my son and his friend Anna in such a cruel and coward way. For him to pay the unbearable damages that he has caused us. Please free us from suffering this agony and despair, and give us full and legitimate justice that our soul, mind, and broken hearts from such pain need. The loss of my son has left unimaginable pain and a huge hole in my heart and soul. Your Honor, we thank you for your attention. Okay, next, Jordana Barrett.
and Rayburn was my brother. I address this court to you to express how the crime committed by the defendant has affected not only me, but all family members and friends. He had a beautiful soul, and this is why I know he is resting in peace. But losing him has left me feeling empty and with a lot of emotional damage. I lost my baby brother and my best friend. The way he had to leave this earth is not something that he deserved. He was a kind, loving person. He deserved a chance in this life. He always wanted to be a father and have a family and live a happy life. And all of that was robbed from him. What the defendant has done with this horrible crime has destroyed our family. Our holidays will never be the same because we are missing a big part of it. This grief and sadness will never be the same because we are missing a big part of it. Okay. Because we are never going to be able to hug our brother on Christmas, on New Year's, or on his birthday. I know how much he loved being with all of his family on all holidays. He never missed a family gathering. So I'm here today to ask for justice for my brother Ray, for Anna, and for my mom, who has to suffer the rest of her life knowing that her youngest son and her baby was taken from her in such a violent way. And that is something that no mother should ever have to go through. The defendant deserves to pay for this horrible crime with the highest sentence possible. He has destroyed many lives, and victims deserve justice. Thank you, Your Honor.
Thank you.
Okay, Elizabeth Barron, next.
Your Honor, my name is Elizabeth Barron, and Rayburn Barron was my baby brother. Even though Ray was the youngest of the 5 of us, he was very responsible and mature from a young age. A true gentleman, always respectful. He was the most loving and kind person to everyone, family, friends, partners, even strangers, no matter the age. He loved to spend time with family and friends. Even if he could not be there in person, he would take time to reach out by call or message. In every family event, he would go around and have a moment with each and every one of us, from the oldest to the youngest. His motto was family comes first. He was a peacemaker, always bringing us together. He was loved by many people, and he touched the hearts of everyone that had the privilege of meeting him. There was not an ounce of bad in him, always trying to help others, even animals. We were not allowed to kill even a spider in his presence. He would kindly just remove it from our home and safely take it outside back to nature. Many of us suffer domestic violence or traumas in our lives, but we choose to be different, to be better. Ray did. He was a great son, brother, cousin, nephew, grandson, friend. And he would have been a great husband and father had the opportunity not be taken away from him. We appreciate and thank all the hard work that the DA team did and the jury for the fair verdict decision that they made. It has taken every strength left in us to be present at court for almost a month and hear and see things that will forever haunt our minds and hearts. But we felt it was important to show our support for everyone that has been hurt with these horrible crimes and see that justice is served. We often are told that we are such a strong family for surviving such tragedy, but the reality is that this has been the most difficult event we have ever experienced, and many of us are left broken. The pain and trauma of losing our brother the way we did is so painful that we have difficulty living a normal and healthy life. Some of us are struggling with depression, anxiety, panic attacks, nightmares, and more. It has been almost 3 years since our loved ones were taken away from us, and we have not been able to have closure waiting for this trial. Just when we feel it's possible to move on and have peace of mind after the verdict, we hear about the intentions of the defendant to ask for even more time and a new trial. Ali Abulaban not only took the lives of two good people, but he also took part of everyone's life that knew Ray and Anna. He did not give Ray or Anna any time to defend themselves or a chance to continue their lives. He does not deserve any more consideration or compassion. That's why we ask with all our hearts that you consider our pain and suffering and deny any further requests from him. Please give us all the justice we deserve so we can finally start healing and find peace in our hearts. Thank you, best regards.
Next will be Sylvia Aaron.
Good morning, Your Honor. My name is Sylvia Barron. I am Ray's aunt. And I say I am Ray's aunt because I didn't have it. I chose not to see him when he passed to the other life. Because I don't want to remember him that way. I remember him for the kind, loving, good man that he was to everyone. My brother Oswaldo was Ray's dad. Dad is a term that Ali Abulaban will never be referred to, will be referred by. The tragedy that he has brought into our lives cannot be described no matter how hard I try. The pain and suffering of others is something that you have absolutely no clue about, Ali Abulaban. You are the only one that matters. I understand they're preparing you for life in prison. And I ask myself, who prepared any of us that loved Ray so much to live life without him? From the moment I received the call from my niece Lisbeth, Ray's sister, I refused to accept the reality of what I was hearing. It just did not make sense. And I kept thinking, this only happens in movies, happens in maybe in other people's lives, not in ours. Suddenly, all I could think about was my dear sister-in-law, Lupita, Ray's mother. How was I going to face her as a mother myself? How could any of us mothers know, except that we lose a child in such a way that is making no sense? No one will ever grieve more the loss of a child than a mother. Just a few months before, Ray, along with all of his cousins and brothers, spearheaded a Mother's Day celebration for their grandmother, my mother, who is now 91 years old, who to this day believes that Ray died of a heart attack because we had to keep it away from her, the horrible, horrible murder that he died by. I couldn't make myself, like I said, see him in his coffin. I will hang on to that sweet image of him making over his mother, his grandmother. He was the perfect nephew, the perfect brother, the perfect citizen. He was a great man, something you will ever, ever know what it's about, Ali Abulaban. How many victims did your cowardness leave behind? Let's start with your own family. The disgrace of being related to a criminal that will hopefully rot in jail. Your mother who will see you die day by day in prison. You won't be dead like Ray, but you will also not be living. And then there's Amira, poor child. Not even your own daughter, now an orphan, mattered to you. And let's not forget Anna's mother and sister and all of the family who also lost a granddaughter, a niece. And then there are all the wonderful friends that Ray and Anna had. Your sick narcissism cut short two beautiful lives at their prime and left a devastation of broken hearts on Ray's and Anna's side, and your side as well. And I hope that you will get the maximum sentence, what you deserve. You deserve no better. Thank you, Your Honor.
Thank you, ma'am.
Honor, there should be one more speaker, and let me make sure he's on Teams.
All right, while you're doing that, to the victim's family, there's something that I like to point out in these circumstances because it's often not understood. Sure. Is the sentence pronounced today does not reflect the value of your loved ones, the value of human life. It can't do that. And I want to emphasize that the sentence today does not reflect your love for them or their value as human beings. It's society's only way to punish people who have done wrong. But it obviously cannot restore their lives. The only thing this court can do, and society in general, is to take away his freedom. But that's it. And I just want to point that out because oftentimes people think that the sentence that is handed down is a reflection of either the crime or the person who is now deceased, and that's just not true. And I just want to point that out to you so that you understand that. All right, Madam Prosecutor.
Thank you. The next statement will be from Ron Miller.
This is Ron Miller. I'm the father of Anne Marie. My wife and I received a phone call from one of Anne Marie's friends in San Diego back in the day of the murder. And nobody knew what happened. They just knew that they just told us that they couldn't get in to see Anne Marie. The apartment was surrounded by police. Well, I called the San Diego Police Department from the Philippines here where we live. But I was informed that even though I'm the father and the mother is right here with me, that they could not give us any information over the phone. They couldn't tell us anything. And I gave them the name of our daughter in New Mexico so they could call her. And my dad already knew what happened. I already knew that she had been murdered. And we just waited for the final word from our daughter when they got the word from the police department that she was murdered. I'm kind of off script here a little bit. You got, please understand, this is extremely hard. We had Anne Marie's body returned here to the Philippines, where we could lay her to rest here, and where we go and visit her once a week. We go to the cemetery and visit with her. We haven't got over this. Imagine it together, maybe you can't, but how I feel about losing my youngest child to the man that promised to love and take care of her and her granddaughter. And he ends up murdering her. My wife and I, we tried to understand why, or what could we have done to have changed the outcome of this. Watching the trial, hearing the verdict of guilty of first-degree murder does bring some closure. But I would love to see a sentence of life in prison without parole. This is what this guy needs. I don't consider him a man. A man would not do this. But I hope he gets life in prison without parole. I want him to rot in prison for what he done to my daughter. She was a beautiful, loving woman. She done everything for everybody else, always putting herself flat. I ask you to please take into account all the consequences of suffering that we as the victims and the family of the victims have gone through and continue to go through because the choice is made by this person. I believe right now that the defendant is a danger to the defendant. He knew what he was doing from the first moment that he started abusing Anna Marie. And I ask you, please, not forgive those victims that are here, because he is not. He deserves to be punished after terrifying and abusing Anna Maria and his daughter, who witnessed so much of the abuse, and for making us live in just deep pain for the rest of our life. He doesn't deserve mercy. That he has no mercy for my daughter, Anna Marie. Thank you, Your Honor.
Thank you, sir.
Thank you, Your Honor, for listening to all the impact statements. I would ask the court to sentence the defendant consecutively on this case for counts 1 and 2. I did, in my brief, cite a case, People versus Garnica, that stands for the fact that the court can impose consecutive life without parole sentences for each murder. Since there are 2 murders here, there's no murder more deserving than another for the LWOP sentence or a state sentence, and so I would ask the court to sentence the defendant consecutively. Count 1, LWOP, life without parole, plus 25 years to life for the enhancement, and a consecutive LWOP sentence on count 2 with another consecutive 25 to life sentence for the enhancement. I laid all of the aggravating factors in this case out in my brief. I would ask the court not to strike any of the enhancements. The aggravating factors here far outweigh any mitigating in the fact that this crime involved great violence, it involved death, it involved the use of a firearm, it involved 2 vulnerable victims who were unarmed. The defendant took advantage of a position of trust, using a key card to enter an apartment he no longer was living in. These were planned crimes, planned executions, not heat of passion crimes. And the defendant has shown that he has exhibited violent conduct, proving he's a danger to society. So for all of the aggravating factors here, I would ask the court not only not to strike any enhancements, but to give the defendant a sentence of consecutive LWOP terms. I would also ask for restitution. There is a victim compensation board claim for $12,890. That is for the funeral expenses for both Anna and Ray. There are also 2 other requests. Amalia Miller and Ron Miller, Anna's parents, live in the Philippines. They had to get a visa to fly out here. That was quite a lengthy process. They wanted to be out here for the trial. They did fly out here. The trial ended up being continued after they were here. That flight cost was $3,324.24. The other request for restitution is to Hermé Sartin, HERMAE-SARTIN. She had to fly out here 3 times, once for the funeral, once to take care and close up Anna's apartment and take the items from the apartment, and then flew here for sentencing to represent the family and make an impact statement. That amount requested is $1,214.66. Under Penal Code 1202.4, families of victims are entitled to economic losses. That includes economic losses for trial. I can give the court a citation to People versus Chrysler.
Well, I'll tell you what, today is really not the day to talk about this, I don't think. Counsel, will your client waive his right to be present at any restitution hearing, and we can sort this out at a later date?
Your Honor, I had an opportunity to speak with Mr. Boulevard prior to beginning the sentencing. He is prepared to stipulate to the restitution being sought by prosecution.
Okay.
Thank you. So the people would ask those amounts be ordered, also for the court to reserve restitution for any remaining amounts or counseling that is sought in the future. I would ask the court, as the victims that have asked, for the maximum sentence. That is the only sentence that will properly punish this defendant, prevent his future crimes, deter others, and protect the community. After judgment in this case, I have informed all parties that people are filing a Penal Code Section 1203.01 statement. That's a packet that gets sent to CDCR with the defendant. Thank you.
You're up.
Your Honor, we just want to start off by saying that Mr. Boulevard and his defense team and everyone involved in representing him does have great sympathy and empathy for the victims of this case and their loss. Hearing their words, it is unimaginable the pain and suffering that they're experiencing. But I think the court's comments reflect very sadly what is the reality in that what they are actually seeking and what they really want, very sadly, they will never have, which is their family members returned to them. And what we have to do here is decide what is a fair and just punishment, not only based on the crime that was committed, but also judging the person who was accused and ultimately convicted of this crime. While we have expressed remorse and sympathy for the victims, it's also important to understand who Mr. Abulaban is. We know that it makes common sense and is common knowledge that we as people are a product of the environments in which we grow up, the environments in which we spend our formative years learning how to respond to emotional crises, how to properly reflect on our decisions and the consequences of our decisions. And when someone is exposed to the type of violence that Mr. Abulaban was exposed to as a child, it leaves an imprint. As we know, again, it's common sense, but we know this from the literature, it leaves an imprint on the human mind. And Mr. Abulaban is someone who I think the court can see from his mother's testimony, from the doctor's testimony, and from his own testimony. He is someone who was fundamentally and is fundamentally stunted emotionally. He is someone who suffers from extreme mental illness that for the majority of his life went undiagnosed and untreated. He is someone who, because of the impact of the violence and trauma that he experienced growing up, that left this imprint that formed him into the person that he is, because of the mental illness that was unchecked and raging throughout his brain, developed an extreme addiction to cocaine that also then had an impact on the decisions that he made, in particular leading up to the incident and on the day of the incident. And while we respect the verdict that was handed down by the jury, we still believe that Mr. Abulaban was acting under heat of passion when he committed the crimes that he did. We are asking the court to consider all of the evidence that it heard, both from the prosecution's witnesses as well as the defense witnesses, as well as from Mr. Abulaban, from his family, from his friends, from the people who knew him and loved him as a son, as a father, as a friend, as a brother, as a husband. With all of his flaws and all of the terrible decisions and reactions that he had, we are asking this court to sentence him to a just sentence, imposing the court's hand to tie with the ultimate sentence of life without parole. But I would ask the court to run the life without parole concurrently. I would also ask the court to strike the punishment on the 12 to 2.53D. I don't think that there is any justification for imposing an additional 25 to life on each count, given that Mr. Abulaban, based on what is the anticipated sentence, will spend the rest of his life in prison without the possibility of parole. And we are asking the court to make this tough decision, but the just decision and the right decision in sentencing Mr. Abulaban.
moment was an unintended, impulsive reaction against my better judgment to the discovery of Ray's romantic involvement with my wife. And for that, I'm sorry. I'm sorry that in that moment I was not mentally strong. Good morning, everyone. In a situation like this, there really isn't much a person can say that can help make things better. Losing a loved one to senseless and unnecessary violence isn't something that anyone should have to go through. And yet, it has happened. And here I am being the reason why multiple families have had to experience it. I can't say that I'm proud of that. Throughout this trial, many horrific things were displayed. And as we sat here for weeks having to endure some of the most disturbing audio recordings and video footage, I sat there in silence, listening, watching, and being reminded of the worst moments of my life. Having to hear myself say some of the most vile, shocking, and hateful things to the woman I loved was not easy. In fact, I couldn't help but at times close my eyes and cover my ears, because that's not who I am. My behavior was disgusting and completely unacceptable. So when the time came for me to take the stand, I tried as best as I could to help make some sense of all this. To explain that everything you all saw in the last few months leading up to this incident was a horrific result of the tragic downfall to a once beautiful relationship. But even so, in those 3 days that I took the stand, I was able to share and say a lot of things, except the one thing I wanted to say the most. I am so incredibly sorry to each and every one of you who have been affected by this. I cannot imagine the pain that I've caused your families. I saw the look on all your faces and the tears in your eyes, and I hate that I'm the reason for it. On that day of October 21st, 2021, I was in the worst physical and mental state of my life. I was sick, suffering from an untreated, severe, in a state of a drug-induced psychosis. My response in that moment was an unintended, impulsive reaction against my better judgment to the discovery of Ray's romantic involvement with my wife. And for that, I'm sorry. I'm sorry that my horrendous action that day resulted in the undeserved deaths of Rayburn Barone and Anna Marie Abulabad. My partner, my best friend, the mother of my daughter, and the love of my life. I am ashamed of what took place to Anna's family, to Ray's family, and to my family. If I could undo all of this, I wouldn't hesitate. If I could go back to that day, I would have left for LA first thing in the morning as I had originally planned. I would have given Anna the space she wanted, and I would have used that time to focus on getting the proper help I so desperately needed. And I would get on my becoming distracted, for letting my anxiety and my insecurities affect my thoughts and my behavior towards Anna and towards her friends. Forgiveness for using cocaine as a remedy and becoming addicted because of it. For neglecting my responsibilities to you, Anna, as your husband, and my responsibilities as a father. And for allowing the drugs to turn me into a pathetic empty shell of the man that she fell in love with. Because of those factors, I lost myself. And because of those factors, I lost Anna. I am so deeply sorry to each and every one of you who have suffered for the last 3 years. To the Cardenas Barone family, to raise mother and father, I am so sorry for what I've done to your son. To Jordana and his siblings, I am so sorry for what I've done to your brother. I really wish I could have gotten to know Ray the way that you all do, the way his friends did. And now, after seeing just how consistently you all showed up to this trial in support of him, I have no doubt in my mind that Ray was a good person. The world has truly suffered a great loss, and for that, I'm terribly sorry. I wish this never happened. To Anna Marie's family, whom I still love and consider to be my family, there's so much I want to say. To Anna's mother, Amalia, and to Ron, you trusted me to protect your daughter, and I failed you. I wish there was something more I could offer besides an apology. I wish there was a way for me to fix this. I'm terrible. Anna was the most beautiful woman I've ever met, and I wanted to spend the rest of my life with her. To love and cherish her, never to hurt her, to build her up, not to break her down. But I failed. I am thankful, however, that Anna and I were able to have a child, a granddaughter for both of our families to rejoice with. It is my belief that the love and spirit that Anna radiated will continue on through her. To Amira, my beloved daughter. Amira, when you're old enough to see this, please don't blame yourself. None of this is your fault. Your mom loved you so much, and I love you so much. You are the strongest girl I have ever known, and I'm so proud to be your father. I'm sorry for what my foolish actions have costed you, from what's been taken from you. I'm sorry that now you not only have to grow up without your mother, but now you have to grow up without your father too. I'm ashamed. But that is why I will strive each and every day to better myself, to seek rehabilitation, and to hopefully one day come back home to you. Because not being a part of your daily life tears me apart. To the Honorable Judge Frazier, I want to thank you for being extremely fair to me throughout this trial and for giving me the opportunity to defend myself. It is truly unfortunate that despite the compelling evidence that this was a crime of passion, somehow the jury still landed on this verdict, and they certainly wasted no time in doing so. The fact that I spent more time on the stand than the jury took to deliberate my fate is very concerning. In fact, the jury foreman himself told Fox 5 news reporters that a few of the jurors wanted to pick second degree, but were pressured not to by the rest of the jury. I think that speaks for itself, loud and clear, that reasonable doubt was intentionally overlooked, and that justice was not the motivating factor behind the decision. It was vengeance. And now I am left with no other option but to spend the rest of my life in prison. Death by incarceration. A very slow and drawn-out death sentence. That means in 50 years from now, should I still be alive, I would still not be considered for release. I don't think that's fair at all. Especially after it has been made clear that drugs and alcohol were involved. And add that to, along with infidelity and mental illness, and you've got a recipe for disaster. One that anyone could fall into. It's happening and I still can't believe it. Being sent to prison without the hope of ever getting out honestly feels like I'm being sent to hell. And that's terrifying. think that's right either. Personally, I believe everyone should have the ability to parole, but nonetheless, even still, it is my goal to serve my time with the utmost outstanding conduct and to participate in every rehabilitative program while being a positive role model to other prisoners. And I will do all this to the best of my ability with the goal of one day safely transitioning back into society. And finally, to everyone else, I extend my deepest apology from the bottom of my heart. I'm sorry. I wish you all peace, healing, love, and abundant joy in your future. I will continue to pray that I may earn your forgiveness. Thank you.
All right. First, we'll take care of some preliminary matters. As a matter of law, the defendant is ineligible for probation. But if he was eligible for probation, this court would not give him probation. The court acknowledges its discretion and obligation at reviewing verdicts from when we get first-degree murders to see if it's second-degree or even voluntary manslaughter. And I will explain also, as the defense has asked, that I have the authority to strike or reduce the gun enhancements. I also have the authority to run the LWOP sentences consecutive or concurrent. And let me kind of briefly go through that and why I am giving the sentence that I am giving. First of all, as to the first-degree murder, I look at various factors, having sat through the trial. And I do this in every murder trial. And I don't take this lightly. I truly respect jury verdicts. Have I reduced a first-degree murder to second degree? I have. In fact, I did it 2 weeks ago. But I'm not doing it today. And I'll explain why it's not happening today. A very simple reason. The jury heard all of the evidence. The jury evaluated all of the evidence. The jury came back with a first-degree verdict, which was the correct verdict. It was a verdict that, when you look at the totality of all that happened during this particular crime, it's the only verdict a reasonable person could come up with. And considering all the evidence, and I'll just hit a few high points that I think, honestly, the jury was looking at. The defendant's text message to his cousin about killing. Defendant's controlling, demeaning behavior. And he said just a few minutes ago, he wants us to know who he is. That's who he is. It's very clear from the videos. His driving over to the apartment with a loaded gun. The fact that the victims were helpless, completely taken by surprise. The planning of a listening device. Firing within seconds of entering the apartment. Clearly showing an intent to kill. Not heat of passion. Willful, deliberate, premeditated, cold-blooded murder. And something that is hard to explain. Ray was not involved in their problems at all. But he shot Ray first. Shot him in the head in an attempt to kill. You don't shoot people in the head unless you want to kill them. And in front of Ahmad. That was deliberate. He wanted her to see it. Very cruel. He took photos immediately afterwards. Who does that? Calls his mother. He had 3 days on the stand to explain his actions. He explained them. And the jurors came up again with the only reasonable verdict, which is a first-degree verdict. They also found, because there was 2 deaths, that this was multiple murder. The Penal Code Section 190.28. The next thing this court has to consider is the gun enhancements. In the state of California, the legislature has both slowly and quickly changed certain enhancements, and the court is obligated to look at or have a 20-plus year addition to the sentence. And again, I look at both mitigating and aggravating factors. Of course, it goes without saying this crime involved great violence, it involved a firearm, it involved vulnerable witnesses, victims, who, again, had no time to react, no time to defend themselves. It involved planning. I don't think you could say it was sophistication or professionalism, but it certainly involved planning. When you load a gun, arm yourself with a gun, drive 10 or 15 minutes to an apartment complex, as we saw on video, his demeanor going up the elevator, his demeanor going down the elevator, that showed planning. And obviously it was he took advantage of a position of trust. Clearly, that she didn't know he had a key, but he took advantage of that. Now, there are certain factors that, as for mitigating factors under the rules of court, I don't find any. Zero. None. There are certain factors with the defendant that I am obligated to take a look at. I acknowledge he has no prior record. I acknowledge the fact that at the time of this killing, he was suffering substance abuse and had some mental health issues. But I reject the fact that his childhood contributed to this at all. I hear terrible childhoods day in and day out. And his was not ideal, but it wasn't what we hear in this particular court. And I don't think that any of these crimes were connected, in fact, to his mental health or even his substance abuse. He was over 26. It did involve intimate partner violence, but he was the one that was committing the violence on her. And of course, he denied when confronted with it what happened initially. So, the court is not going to strike or reduce the gun enhancements. The question then becomes one of whether or not these life without possibility of parole should be consecutive or concurrent. And that's a big deal. That will, in all likelihood, determine whether or not he dies in prison or out of prison, whether he dies a free man or one who's not. And this is the bottom line on this, is I've watched him here during all of this time. He's a very talented actor. He is a very talented actor. When I saw the Scarface videos, it's as if when he committed these crimes, he became that persona of Scarface. Just cold-blooded killing without remorse. Any tears that he's cried in this courtroom have been for himself. They are not for Ray and Anna. It's just, that's the reality. He fears the consequences, as he should, of his actions. But as he sits here today, I don't know if he's really sorry. I have serious reservations about it. I know he's sorry about the consequences of going to prison for the rest of his life. But I can't say that I think he's sorry for having killed these two innocent human beings. He's a very selfish person, as I think the jury saw. That was something that his character kind of came through when we asked, who is Ali Abulaban? That's who he is. He's somebody that is only thinking about himself, and the idea of killing two innocent people doesn't disturb him. It's chilling. So the bottom line here is he will die in prison. He will never be a free man. He will take his last breath. In this matter, the defendant on count 1 will be sentenced to life without the possibility of probation via Penal Code Section 1190.2, Parent A, Parent 3. Consecutive to that will be 25 years to life on the gun enhancement under Penal Code Section 1222.53D. Consecutive to count 1 will be count 2, which will be life without the possibility of parole. Penal Code Section 190.2, Parent A 3. Consecutive to that will be the gun enhancement of 25 to life under Penal Code Section 1222.53D. Total prison term, 50 years to life plus LWOP. Life without the possibility of parole. He's given the following custody credits: 1,552 days. He is given the following fines and fees.
Your Honor, probation has credits of 1,052 as of today.
Okay, 1,052. He will pay a restitution fine of $10,000 under Penal Code Section 1202.4B. Court security fee of $80 under Penal Code Section 1465.8. Criminal conviction fee of $60. The general order of restitution. Restitution at today's time will be set at for the funeral expenses of $12,890. And what was your other restitution amounts?
Just so the record is clear, that $12,890 is to the Victim Compensation Board.
Correct.
The amount to Amalia Miller is $3,324.24.
We can cancel that, Mr.
I can't. Please, don't interrupt. Go ahead.
And the amount to Hermé Sarton is $1,214.66.
All right. Those amounts were also All right. Thank you all.
Your Honor, may I just want to make one clarification. When the court announced the sentence, 50 to life plus LWOP, is that plus 2 terms of LWOP, one for each count?
As I indicated, the counts 1 and 2 on LWOP under the special circumstances alleged and pled and proven under Penal Code Section 190.2, Parent A, are consecutive to each other.
Thank
That's
you.
2 consecutive LWOP terms, plus on each count, 25 to life, totaling 50 to life, plus LWOP. So yes, they are consecutive to each other.
Thank you.
Yeah. All right. I need the results.
You all may be seated. Okay, are we ready to proceed?
Yes,
Yes, Your Honor.
Okay. Are there any representations that you'd like to make?
Your Honor, it is my understanding that Mr. Redden is going to plead guilty but mentally ill to all of the charges in the second amended indictment that was previously filed. The state is willing to stipulate to allow him to withdraw his prior pleas of guilty so that he can enter pleas of guilty but mentally ill to counts 2 through 7. And he's also pleading guilty but mentally ill to count 1.
And that's our understanding, Your Honor, and he's prepared to go forward with the plea agreement.
Okay. All right.
But in terms of the negotiations, Your Honor, there are no negotiations. Each side will argue for a lawful sentence under the statute.
Okay. All right. Mr. Redden?
Yes.
I'm going to be asking your lawyer to state in open court the substance of the plea agreement. In other words, the primary, the most important terms of the negotiations or agreement between you and the state. Actually, this is a guilty plea memorandum.
Correct.
Okay. I want you to listen carefully, as after your lawyer's done speaking, I'm going to ask you if you heard him and if you agree that this is what the parties have agreed to enter into. All right?
Okay.
Okay. Mr. Arnold?
Your Honor, he's agreed to plead guilty, but mentally ill to count 1, attempted murder, victim 60 years of age or older. Count 2, battery on a protected person, resulting in substantial bodily harm, victim over 60 years of age or older. Count 3, intimidating a public officer. Count 4, battery on an officer resulting in substantial bodily harm. Count 5, performance of act or neglect of duty in willful or wanton disregard of safety of persons or property, resulting in substantial bodily harm or death. Count 6, battery by prisoner. Count 7, unlawful act related to human excrement or bodily fluid.
Okay. And this is what I will do. Once I canvass Mr. Redden, I will go ahead and allow him to withdraw his guilty plea with respect to the counts 2 through 7.
Thank you, Your Honor.
Did I get the numbers right?
Yes.
Okay. All right. Mr. Redden?
Yes.
Did you hear your lawyer just state the substance of the guilty plea memorandum?
Yes.
Okay. Did he accurately state the terms that you had agreed in order to resolve the criminal charges lodged against you?
Yes.
Do you read, write, and understand the English language?
I do.
Okay. Did you receive a copy of the guilty plea memorandum?
I did.
Did you review the second amendment indictment? Okay. Do you need me to read the indictment now? Accepting your guilty plea, there's a number of questions I'm going to have to ask you in order to assure me you are entering a valid plea. If you do not understand any of my questions, will you please let me know so that I can rephrase them?
I will.
If at any time you wish to take a break in the proceedings so that you can discuss matters in private with your lawyer, will you let me know so that I can give you an opportunity to do so?
Yes.
How old are you, sir?
I'm 31.
Where were you born?
Las Vegas, Nevada.
What is the extent of your education?
12.
Did you graduate from high school?
No.
Would it be fair to say you dropped out in the 12th grade?
Yes.
Okay. You finished the 11th grade?
Yes.
Okay. Are you taking any medications or suffering from any medical, physical, or mental health conditions that would interfere with your ability to understand these proceedings and the terms of the guilty plea memorandum?
I am on mental health meds, but as long as I'm on that, I don't believe that it will affect any of my resistance.
Well, I know that you've got to be on some medication, sir. I think we've been discussing that here today. But I want to know, are you taking any medications or suffering from any medical, physical, or mental health conditions that would interfere with your ability to understand what is going on here today or the terms of the guilty plea memorandum?
Oh, no.
You fully understand?
Yes.
Have you had an ample opportunity to discuss your case with your lawyer, Mr. Arnold?
Yes.
Are you satisfied to have him as your lawyer and the advice that he has given to you?
Yes.
Do you understand you are entitled to have an attorney represent you at every stage of the proceeding lodged against you?
Yes.
Do you understand you're entitled to a trial by jury, at which in order to convict you, all of the jurors would have to agree that you are guilty?
Yes.
Do you understand at trial you would be presumed to be innocent, and the state would have to overcome that presumption and prove you guilty beyond a reasonable doubt?
Yes.
Do you understand that to do this, the witnesses for the state would have to come to court and testify in your presence, and your lawyer could cross-examine those witnesses?
Yes.
Do you also understand that your lawyer could object to evidence offered by the state at the trial and could call witnesses and present evidence on your behalf?
Yes.
Do you understand at trial, while you have the right to testify if you chose to do so, you also would have the right not to testify, and if you decided not to testify at your trial, the state would not be able to use the fact you did not testify in any way to prove its case?
Yes.
Do you understand that by entering your guilty pleas, you are giving up these rights and other rights listed in the guilty plea memorandum?
Yes.
Are you aware of the penalties for committing the crimes which are listed in count 1 through count 7?
Yes.
I'd like to review all of them with you. This will take a little bit of time, but I want to make sure you understand, okay? Do you understand, as a consequence of entering a plea of guilty but mentally ill, you have the burden of establishing your mental illness by a preponderance of the evidence?
Oh, yes.
Do you understand that except as otherwise provided by specific statute, as a defendant who has entered such a plea, you would be subject to the same criminal, civil, and administrative penalties and procedures as a defendant who regularly just pleads guilty?
What?
Sure. Do you understand, except as provided by specific statute, as a defendant who has entered a plea of guilty but mentally ill, you are subject to the same criminal, civil, and administrative penalties and procedures as a defendant who pleads guilty?
Yes.
Okay. Okay, do you understand that if the court finds by a preponderance of the evidence you are not mentally ill at the time of sentencing, that the court may impose any sentence that the court is authorized to impose upon a defendant who pleads or is found guilty of the same offense, or that you are mentally ill at the time of sentencing, or if you are mentally ill at the time of sentencing, the court shall impose any sentence the court is authorized to impose upon a defendant who pleads or is found guilty of the same offense, and include in that sentence an order that you, during the period of your confinement or probation, be given or obtain such treatment as is medically indicated for your mental illness. Do you understand that?
Yes.
That's all set forth on page 2 of the guilty plea memorandum. Okay, do you understand that as a consequence of your plea of guilty but mentally ill, the court must sentence you as follows? First, with respect to count 1, the court must sentence you to imprisonment in the Nevada Department of Corrections for a minimum term of not less than 2 years and a maximum term of not more than 20 years, plus a consecutive sentence of 1 year to 20 years for the age enhancement. Do you understand that?
Yes.
Do you understand the minimum term of imprisonment may not exceed 40% of the maximum term of imprisonment?
Yes.
Do you also understand that you also may be fined?
Yes.
Okay. Do you understand that you are eligible for probation for the offense to which you are pleading guilty?
Yes, I understand.
Do you also understand, except as provided by statute, the question of whether you receive probation is in the discretion of the sentencing judge?
Yes.
With respect to count 2, do you understand that the court must sentence you to imprisonment in the Nevada Department of Corrections for a minimum term of not less than 2 years and a maximum term of not more than 10 years, plus a consecutive sentence of 2 years, minimum 2 years, to 10 years for the age enhancement?
Yes.
Do you, again, as with count 1, do you understand that the minimum term of imprisonment may not exceed 40% of the maximum term of imprisonment?
Yes.
Do you also understand in that situation you may also be fined for that?
Yes.
And as like count 1, do you also understand you are eligible for probation for the offense to which you are pleading guilty, meaning count 2?
Yes.
With respect to count 3, do you understand that the court must sentence you to imprisonment in the Nevada Department of Corrections for a minimum term of not less than 1 year and a maximum term of not more than 5 years?
Yes.
Do you also understand that you could be fined up to $10,000?
Yes.
And as with respect to counts 1 and 2, the minimum term of imprisonment may not exceed 40% of the maximum term of imprisonment?
Yes.
And I might save a little bit of time, but the minimum term of imprisonment may not exceed 40% of the maximum term of imprisonment would also apply to counts 4, 5, and 6 and 7. Do you understand that?
Yes.
Okay. And you also understand that you are eligible for probation with
Yes.
respect to those other counts?
Yes.
As well as count 3?
Yes.
Your Honor, I think count 7 is actually non-probationable.
Okay. Okay. I will get to count 7. I thank you, counsel, for doing that. You are not eligible for probation with respect to count 7. We will get to that in a few moments. Do you understand that?
Yes.
Okay. With respect to count 4, do you understand the court must sentence you to imprisonment in the Nevada Department of Corrections for a minimum term of not less than 2 years and a maximum term of not more than 10 years?
Yes.
Do you understand in that instance you may be fined up to $10,000?
Yes.
With respect to count 5, do you understand that the court must sentence you to imprisonment in the Nevada Department of Corrections for a minimum term of not less than 1 year and a maximum term of not more than 5 years?
Yes.
Do you also understand you could be fined up to $10,000 with respect to that count?
Yes.
With respect to count 6, do you understand that the court must sentence you to imprisonment in the Nevada Department of Corrections for a minimum term of not less than 1 year and a maximum term of not more than 6 years?
Yes.
Do you also understand in that instance you could be fined up to $5,000?
Yes.
Okay, and that again is with respect to count 6. With respect to count 7, do you understand that the court must sentence you to imprisonment in the Nevada Department of Corrections for a minimum term of not less than 2 years and a maximum term of not more than 10 years?
Yes.
Okay, and you do understand that you are not eligible for probation for the offense to which you're pleading guilty with respect to count 7?
Yes.
And do you understand you could also be fined up to $10,000?
Yes.
And in any case, that the law does require you to pay certain administrative assessment fees?
Yes.
Do you also understand the court may order you to make restitution to any victim of the offense to which you are pleading guilty?
Yes.
Has anyone threatened you or forced you to plead guilty but mentally ill?
No.
Has anyone told you if you do not plead guilty but mentally ill, some other adverse action will be taken against you?
No.
And I take it that you have you've received a copy of the guilty plea memorandum.
Yes.
Okay. A signature prior with your lawyer before you signed it.
Yeah, I did.
Did he answer all of your questions?
Yes, he did.
Did you sign the guilty plea memorandum willfully, knowingly, and voluntarily?
Yes.
Do you feel you understand the terms of the guilty plea memorandum?
I do.
Has anyone made any promise to you other than those set forth within the guilty plea memorandum that induced or caused you to plead guilty but mentally ill?
Say that one more time.
Sure. Has anyone made any promise to you other than those set forth within the guilty plea memorandum that induced or caused you to plead guilty but mentally ill?
No.
You understand that later on, when there are requests with respect to sentences or any sentences that may be agreed to by your lawyer, and the lawyers for the state would not be binding upon the sentencing judge?
I don't understand what that means.
Do you understand that sentencing is totally up to me?
Okay, yes.
That's irrespective of whatever your attorney argues to me. If later on there's deals made between your lawyer and the lawyers for the state, I don't have to abide by those deals. You understand that?
Yes.
Okay. And do you also understand that you might, on the basis of your guilty plea but mentally ill, receive, if there was any deals going on, that you could receive a more severe sentence than that, either requested, recommended, stipulated, argued by your lawyer?
Yes.
Okay. Do you have any questions as to what you're alleged to have done within the second amended indictment?
No.
Do I need to review all that with him?
He's never been canvassed as to count one, Your Honor. I think the parties can agree to incorporate the factual basis from his previous plea as to counts 2 through 7, but he's never been canvassed as to count one.
Okay, let me go through that. I don't have that right in front of me, so let me pull it up. I'm going to go through all the counts.
Thank you, Your Honor.
Okay. Okay, I'm looking at the, well, it's called the amended indictment. And it was filed on August 30th.
It's the second amendment that was filed on Tuesday, Your Honor. That's the charging document we're going on with.
Okay. Okay, I need it. Yeah, apparently it was filed in open court, counsel, and for whatever reason, hasn't made it yet, but they're going to do it like right this minute. I'm going to email them right now, Your Honor.
I can email the court a copy if you want to read them electronically.
If you got a file stamp on it, I'd be happy to do that.
Let me see if I can. Let's see if you have a copy of that.
In fact, counsel, would you approach?
Sure.
Okay, I've got it, Ms. Mercer.
Thank you.
Okay. Okay, Mr. Redden?
Yes.
She's got a copy that is file stamped, well, it's not file stamped, but it is the one that was filed. I'm going to go ahead and review the second amended indictment with you, if I may, and tell me if this is what you did. And again, you're pleading guilty but mentally ill. I appreciate that, so I may not add all of that. Okay, tell me if this is what you did with respect to count 1, attempt murder victim 60 years of age or older, that you willfully, unlawfully, and feloniously, and with malice aforethought, attempt to kill Judge Mary Kay Holthus, who is 60 years of age or older, to wit, during your rendition of sentence, and once you knew she was about to sentence you to prison, did leap over defense counsel's table into the well of the courtroom, and thereafter rushing towards the judicial bench and jumping over it Superman style directly into Judge Mary Kay Holthus's judicial space, landing directly on top of her and immediately attacking Judge Mary Kay Holthus by grabbing her, pulling her hair, placing your hands around her throat, and or hitting her on the head by manner and means unknown. Did you do that, sir?
Yes.
Okay. With respect to count 2, tell me if this is what you did. That, and by the way, this is on or about January 3rd, 2024 in Clark County, Nevada. That with respect to battery on protected person resulting in substantial bodily harm, victim over 60 years of age or older, that you did willfully, unlawfully, and knowingly use force or violence upon the person of another, to wit, Judge Mary Kay Holthus, who is 60 years of age or older and is a protected person employed as an 8th Judicial District Court judge while Judge Mary Kay Holthus was performing the duties of an 8th Judicial District Court judge, which you knew or should have known that Judge Mary Kay Holthus was an 8th Judicial District Court judge by grabbing her, pulling her hair, placing your hands around her throat, and or hitting her on the head by manner and means unknown, resulting in substantial bodily harm to Judge Mary Kay Holthus. Did you do that, sir?
Yes.
Okay, with respect to count 3, intimidating public officer, that on the same date, place, and time, that tell me if this is what you did, that you did willfully, unlawfully, and feloniously, directly or indirectly, address any threat or intimidation to a public officer, namely Judge Mary Kay Holthus, a judicial officer with intent to induce her, contrary to her duty to do, make, omit, or delay any act, decision, or determination with use of physical force or the immediate threat of such force, to wit, during the rendition of sentence, and once you knew she was about to sentence you to prison, did leap over defense counsel's table into the well of the courtroom, thereafter rushing towards the judicial bench and jumping over it Superman style directly into Judge Mary Kay Holthus's judicial space, landing directly on top of her and immediately attacking Judge Mary Kay Holthus by grabbing her, pulling her hair, placing your hands around her throat, and or hitting her on the head by manner and means unknown. Did you do that, sir?
Yes.
Count 4, battery on an officer resulting in substantial bodily harm. On the same date same date and place, tell me if this is what you did, that you did willfully, unlawfully, and knowingly use force or violence upon the person of another, to wit, J. Cobralda, who is performing the duties of a peace officer employed with the Las Vegas Metropolitan Police Department, which you knew or should have known that J. Cobralda was an officer by punching and or kicking and or pushing the officer, such acts resulting in substantial bodily harm. Did you do that, sir?
Yes.
Okay. With respect to count 5, at the same date, place, and time, tell me if this is what you did. That count 5, performance of act or neglect of duty in willful or wanton disregard of safety of persons or property resulting in substantial bodily harm or death, that you did then and there unlawfully, willfully, unlawfully, feloniously perform an act in willful or wanton disregard of the safety of persons or property in the following manner, to wit, by jumping over the defense counsel's table into the well of the courtroom, thereafter rushing at the judicial bench and leaping over it Superman style to attack and or kill the judge, causing Marshal S. Brandon and others to respond in defense of your actions towards the judge, resulting in substantial bodily harm or death to Marshal S. Brandon. Did you do that, sir?
Yes.
Okay. With respect to count 6, battery by prisoner, on the same date, and place and time, tell me if this is what you did, that you did willfully, unlawfully, feloniously, and knowingly use force or violence upon the person of another, to wit, Officer C. Boo, by spitting on Officer C. Boo, defendant you at the time of the offense being a prisoner in lawful custody or confinement. Did you do that, sir?
Yes.
With respect to count 7, on the same date and place, and the act being unlawful act relating to human excrement or bodily fluid, tell me if this is what you did, that you did then and there, willfully, unlawfully, feloniously, and intentionally use, propel, discharge, or spread any human excrement or bodily fluid consisting of saliva with the intent to have the excrement or bodily fluid come into physical contact with any portion of the body of another person, or under circumstances in which the excrement or bodily fluid was reasonably likely to have come into contact with any portion of the body of another person, to wit, Officer C. Boo, whether or not such contact actually occurred while you were a prisoner in lawful confinement, you committing the offense in the following manner, to wit, by spitting saliva on Officer Boo. Did you do that, sir?
Yes.
Okay. And for that reason, you are pleading guilty to committing the crimes by pleading guilty but mentally ill to committing the crimes of count 1, attempt murder, victim 60 years of age or older, a category B felony in violation of NRS 200.010, NRS 200.030, NRS 193.153, and NRS 193.167. Count 2, battery on a protected person, resulting in substantial bodily harm, victim over 60 years of age or older, a Category B felony, in violation of NRS 200.481. Count 3, intimidating public officer, a Category C felony, in violation of NRS 199.300. Count 4, battery on an officer resulting in substantial bodily harm, a Category B felony in violation of NRS 200.481. Count 5? Is that what I'm on? Count 5, performance of act or neglect of duty in willful or wanton disregard of safety of persons or property resulting in substantial bodily harm or death, a Category C felony in violation of NRS 202.595. Count 6, battery by prisoner, a Category B felony in violation of NRS 200.481 2F, and Count 7, unlawful act relating to human excrement or bodily fluid, Category B felony, in violation of NRS 212.189. Is that right, sir?
Yes.
Okay. Is the state satisfied with that canvass?
Yes, Your Honor.
Okay. At this time, I am going to allow Mr. Redden to withdraw his original guilty pleas to counts 2 through 7, and it is the finding of the court the defendant is fully competent and capable of entering an informed plea with respect to the 7 counts, and that your plea of guilty but mentally ill is a knowing and voluntary plea supported by an independent basis in fact, containing the essential elements of the offense charged, and for that reason this court accepts your guilty pleas. We need to give this gentleman a sentencing date.
Yes, and I believe the defense counsel was requesting 60 days.
Yes, Your Honor.
60 days?
Yes, Your Honor.
I think we can accommodate that.
Court's indulgence, Your Honor.
Sure.
Judge, just for the record, was the Mr. Arnold's acknowledgement attached to the guilty plea agreement?
I've got it. Yes. The certificate of counsel?
Yes.
It's there.
Thank you.
Okay. And go ahead.
November the 7th, would you like a special time, Your Honor?
Do you want a special time?
Yes, please.
Usually I have my calendar at 8:30. Do you want to do it after? Or do you want to do it in the afternoon?
We can do 10:30 or 11, or we can do it afternoon. Whatever. Afternoon would be better.
Oh, now this shouldn't be a Wednesday.
No, I'm saying on the Thursday.
Okay. Yeah, because I have gotten where I just don't settle on. There's just no way I can get it done. Right now we've got 6 criminal sessions on that. I could probably do it at noon if you want to just do it at noon.
Whatever Mr. Arnold's preference is.
That's fine, Your Honor.
Okay. We'll just take a later lunch, okay?
November the 7th at noon.
Thank you, Your Honor.
Thank you.
Okay, thank you. And Ms. Clerk, I'd like these documents, Dr. Paglini's report, left side filed, as well as Leo Rowley, Dr. Leo Rowley's report, left side filed. Okay? Okay. And thank you very much. Well, wait, Mr. Arnold, do you want to take the defendant out now? I was going to tell the jury.
Oh, yeah, we don't need him here.
Yeah.
You don't need him?
No, we don't need.
Okay. All right. Are you ready for me to invite the jury in?
Yes, sir.
Okay. Yeah, attach a copy. That'd be great. Sure.
No relevance or bearing on the guilt or innocence of either of the defendants here.
No, it doesn't, but I don't think that's what he's offering it for. I'll permit it.
They told you, they said to the judge that you were too dangerous to let go, right?
Yes.
Okay. When you initialed these acknowledgments that they wrote, they gave you probation, right?
Yes.
And then something came up.
And
Because
I'm sorry. I know that the objection needs to be at the same time, but as I thought about it, that was hearsay as well. What the state told him about his dangerousness or whatever being too dangerous.
I'm not saying it's dangerous.
Literally, the question was, did the state say, no, that's hearsay.
It's not for the truth of the matter asserted.
Overruled.
Again, they said, not saying you're dangerous. They said you were too dangerous to let
Objection,
go.
already asked and answered.
Well, I'm trying to recap because I keep getting interrupted.
Well, she's entitled to interrupt you if she thinks she's got a legitimate evidentiary objection.
Okay. After you initialed these documents next to the statements that they wrote, they gave you probation on count 1, right?
Yes.
Objection, asked and answered.
Okay. Sustained.
And something came up in court because you pled guilty to count 30 but weren't being sentenced. You had to be given a bond on that in order to be released.
Yes.
And all of a sudden on December 28th, after you initialed these statements, the state recommended a signature bond. Isn't that correct?
Yes.
A signature bond means you get released and you don't even have to pay any bond at all, right?
Yes.
Have you ever been able to figure out what made you so dangerous before December 28th?
Sustained.
I have no further questions. Thank you.
All right. Charity, I'll need a break before we move on to the next cross. Okay, let's take a 10-minute or so break. All right, we'll recess